Board meeting to order. My name is Terrence Bond. I'm Vice Chair of the Board, and I'll be presiding over the meeting in the absence of our Chair, Julie Ryan Caputo. For all appellants in person speaking, just to let you know at the top, when you are speaking, you'll come to the table here and you'll speak into the podium. To activate the podium, you'll press the right button one time in order to activate, and then another time to deactivate. And I believe that's all the announcements we have at the top, unless Metro has anything.
Yes, I'll give the introduction at this point. Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for the regularly scheduled meeting of November the 30th, 2022. I am Bonnell McBroom III. I'm the Short-Term Rental Property Chief for the Metro Codes Department, and I'll be presenting the cases to the board for review in today's public hearing. At this time, we would ask everyone to either turn off their cell phones or put them on silence as to not disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to a case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board in their rules provides the appellant on cases without opposition 5 minutes to present their case. In a contested case, the board provides 10 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some of their allotted 10 minutes for the rebuttal. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted, if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through the cases set for the public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on the cases before us today under the provisions as outlined in 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board to be present to constitute a quorum. The board rules require a majority vote in the affirmative for the members present to be granted the appellant's application. In the event that a majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled meeting and vote at the next meeting and public hearing. And if there is not an affirmative vote at the next scheduled public hearing, they shall be deemed denied by operation of law. The appellant or any aggrieved property owner may request a rehearing within 60 days of this public hearing. Further, if the appellant or any aggrieved property owner may also appeal to the board's decision to the Chancery Court within the same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that the permit must be obtained within 2 years of the board approval to remain valid. I submit that all cases have been filed in proper order. All appellants have been notified by certified mail as required by the code, and all affected property owners have been notified, and the legal notification sign requirements have been met as required by the code. At this time, we'd like to recognize any elected officials that would wish to speak to the board. Seeing none, we will proceed to the first case. The first case on our docket is case 2022-402914 Tuggle Avenue. The appellant is Matt Washburn, and this is for advertising and operating a short-term rental without a permit. Is the appellant present? Is there opposition present? Seeing none, there will be 5 minutes for the appellant to make their presentation. This is governed by Bill 2020-187. The decision of the board is whether or not the zoning administrator erred in the denial of the permit. On September the 6th of 2022, the address was on the monthly list provided of properties advertising and operating a permit, without a permit provided by Metro Government's compliance contractor, Granicus Host Compliance, for follow-up investigation. Inspector John Felton's investigation found an Airbnb website advertisement that contained 4 reviews, 1 for July, 2 for August, and 1 for September. A notice of violation was sent by Inspector Feltz for advertising and operating without a short-term rental permit. The notice gave 30 days for the property to comply. October 6, 2022 was the date to be in compliance. September 13th of 2022, Mr. Washburn emailed Inspector Feltz. He indicated that he had received the violation notice and wanted to know how to obtain a permit. Inspector Feltz informed that since the STRP had been advertised and operated without a permit, he would have to wait 1 year before he could apply for the permit as prescribed by the STRP ordinance. And that ordinance, and I quote, BL 2020-187, section 6.28.30.1.2, number 2, upon determination of the zoning administrator or the zoning administrator's designee that a short-term rental property is operated without having obtained a permit, there shall be a waiting period of 1 year from the date such a determination by the zoning administrator or designee for the property to become eligible for an STRP permit. On September the 16th of 2022, Mr. Washburn filed his short-term rental appeal. October 19th of 2022, Inspector Feltz reviewed the ad and found that the ad calendar had been changed to a minimum 30-night stay. He marked the case as complied and closed it. On November 1st, 2022, in the review for the summary of this case, the Airbnb contained 7 reviews. In addition to the 4 previously mentioned reviews, there were 3 reviews for October. There were no complaints for the property on the short-term rental property hotline or the Metropolitan hub.
That concludes Metro's presentation. Mr. Washburn, you're welcome to come forward and present your case. Yes, you're sitting up there. Once again, you'll press the icon on the right to speak. Only press it 1 time to deactivate. If you should happen to press it twice, let me know and I'll have to reset all the microphones. Okay. You'll have 5 minutes to present your case.
Okay. Yeah. Can you guys hear me?
Yes.
Yep. Cool. So I've been at my residence for about 7 years, and most of that time I've had a roommate and rented it out to either 1 person or 2 people in my house. It's a 3-bedroom, 1 bath. When COVID hit, I decided not to have roommates, and money was starting to get tight, and so I was like, I'm going to try to do temporary roommates, which I was using Facebook groups to find people that need like a month stay, a few weeks stay, here in Nashville. So that was slowing down, and I didn't do my research. I'll say, like, I was on a whim. I applied to be, applied on Airbnb for an owner-occupied place to stay. I was not aware that I needed a permit for that, since it was my, primary residence. So as soon as I found out, I was wanting to be in compliance with that. I know for me, there was 2 people that opposed like a letter they sent in, was talking about, traffic and, their concerns with an Airbnb. And, for me, there's honestly less traffic, a lot less traffic by not having roommates full time and them having friends come over all the time. I only plan on renting it out 10 to 15 days, really no more than 15 days, because I just don't want someone at my house 30 days out of the month. And for me, So for that concern, a lot of people are, they're flying in, there's no cars, and, there's no parties at all. It's usually one person staying there. So there hasn't been an issue, and I don't foresee there being an issue, especially with my neighbors. And all my neighbors directly on my street were absolutely fine when I told them that I had to come and do this. And I have a few letters up here. I don't know the best way to share them, or should I read them, or?
Yeah, I was about to say, we can collect those if you'd like to share them.
Okay, yeah.
Is it support?
Yeah, the support for my neighbors.
You're free to read them as long as
Okay.
you can do it within your 5 minutes, or you can hand it out to do something.
Yeah, I'll read them. So this is for my neighbor Sarah. She said, my name is Sarah Steinhaus, and I live at 3002 Togo Avenue. I've been Matt's neighbor for 5 years, and he's always been respectful, considerate. I'm very supportive of Matt's short-term rental license being approved. I do not foresee there being any concerns, and I trust Matt to continue to be respectful when hosting guests. My other neighbor named Sarah, directly across the street from me at 2915 Togo Avenue, said, Matt has been a great neighbor, and I know he will be compliant and respectful out of neighborhood and neighbors. We support him and his short-term rental. This is from Allie and Max at 2907 Togo Avenue. To whom it may concern, my name is Allison Hopkins. My husband and I have owned a house on Tuggle for 5 years. We have come to know Matt first as a neighbor and now as a friend. He's a great neighbor, tidy, communicative, responsible, kind, honest, and respectful. We are in full support of his pursuit of a short-term rental in his home and the capacity that Matt has detailed. I have full confidence that Matt will have his guests treat Tuggle Avenue as he does, with love and respect. Don't hesitate to contact us if you have any questions. So yeah, as far as, being issues and, being respectful to the neighborhood, that's absolutely going to happen. That's not going to be an issue. But as for me personally obtaining this permit, it is to help offset my mortgage. Works slow, and, it really does help out. And yeah, I apologize for not being in compliance before, but if there's anything I can do to get that up and running, and being compliant, yeah, I'm willing to do. So that's all I have.
All right, board members, any questions?
I have one.
Yep.
Just looking at the overall timeline here, I think on September 6th, you received a notice, or that was when the notice was sent out. Pardon me 1 second, please. We get a lot of paperwork over here. It's hard to keep track of. September 6th, September 16th, you were aware September 6th, I think, of the issue of listing without a permit?
Yeah, whenever they emailed me.
And so when was the last stay at your home from the short-term rental websites?
Like a couple weeks after that.
Okay. Thank you. That's the only question I had.
Okay. There are no other questions, then we will close the public hearing and go into deliberation. Thank you, Mr. Washburn. You may return to your seat if you like, or you may stay there.
I'll return to my seat. Yeah.
Well, our authority is limited to
Whether or not
whether or not there was an error. There was no error. So I would move that we deny relief on that basis.
Seconded.
I'll second that with just a brief explanation. I mean, I think you've been told this by staff, but in this particular type of case, we have very little discretion as a body to offer any relief.
All in favor?
Aye.
Aye. All right, Mr. Washburn, your petition for relief is denied, and you will be required to wait You'll be required to wait the 1 year that's specified in the code before you're able to reapply for a permit.
Okay. Thank you.
Thank you.
And just a point of information, going forward, when you, after you vote, even if it's unanimous, you just, as a matter of form, just ask for any opposed, and just so that for the record it's clear. Thank you.
The next case before the board is 2022-41, 1307B Greenwood Avenue. Michael Hoover is the appellant. This is for a DADU that was permitted, and the permit expired, and the property was operated after the expiration of the permit. The DADU is a detached accessory dwelling unit. This is governed by 2017-608. This gives the board discretion to reduce the one-year wait period. On April 16th of 2019, an owner-occupied permit application was initiated. On May the 30th of 2019, the permit was issued. On June the 14th of 2019, an Airbnb website ad was posted. On May 4th of 2020, Inspector John Phelps sent a notice of violation for failure to display the short-term rental property permit number on the website advertisement. On May 18th of 2020, the permit was renewed. On June the 3rd of 2020, the permit number was posted on the website, ad photos, and the case was closed. On May 24th of 2021, the permit was renewed. On May 31st of 2022, the permit expired. On June the 6th of 2022, Program Manager Robert Osborne emailed the appellant with the following note. Michael, I'm reviewing some recently expired permits, and yours expired on May the 30th of 2022. You're within your 30-day grace period to renew. I just wanted to reach out and see if you wanted to renew your permit. The applicant replied, or the appellant replied, we do wish to renew the short-term rental permit. Thanks for reaching out. Let us know what we need to do. Mr. Osborne replied, I've requested the system to send you a new email with instructions on how to renew. It looks like there was a typo in our system, which is why you didn't receive one previously. I've fixed the typo. And Mr. Osborne reopened the permit for renewal and extended the expiration date until June the 30th of 2022, which was the expiration of the 30-day grace period for renewal. The appellant replied, thank you. The permit renewal documents and payment were not received by the Codes Department. During June of 2022, there were 7 documented stays. June the 30th of 2022, the permit expired and the grace period ended. In July of 2022, there were 7 documented stays. In August of 2022, there were 4 documented stays. August 31st of 2022, the address was on the monthly list of properties advertising and operating without a permit or with an expired permit provided by Metro's compliance contractor, Granicus Host Compliance, for follow-up investigation. A notice of violation was sent by Inspector John Phelps for advertising and operating with an expired permit. On September the 16th of 2022, the appellant emailed Mr. Osborne the following. We still need to renew our short-term rental permit. How do we do that now? And Mr. Osborne replied, the permit is now outside the grace period to renew. There's been operation after the permit expired, so you'll have to wait until August 31st of 2023 to be able to apply for a permit. You may appeal to the short-term rental board if you feel I erred in this determination. They may be able to lessen your wait time. If you desire to appeal, please email David Frabit. September 16th of 2022, website advertisements calendar was changed to a 30-night minimum stay. September the 20th of 2022, the short-term rental board appeal was filed. September of 2022, there were 4 documented stays. October of 2022, there were 3 documented stays. There were 25 documented stays after the permit expired, 18 of which occurred after the 30-day grace period for renewal expired. There are no documented complaints on host compliance hotline or the Metro hub for the property.
Are Michael and Heather Hoover present? Okay, if you'd like to approach the podium.
Is there opposition for this case? Seeing no opposition, you'll have 5 minutes to present your case.
And before you begin your presentation, if you'll please state your names and your address, your residential address for the board.
Yeah. Good afternoon. All right, there we go. Michael Hoover, 1307 Greenwood Avenue.
Heather Hoover, 1307 Greenwood Avenue.
Thank you.
So, yeah, the reason we're here today is basically we never received the renewal email. We had the correspondence that he was just describing, but we never actually got the email to do the renewal. You guys are probably aware that Metro changed to they're not sending out any actual renewals through the mail this year. They started in 2022. So, and he, even admitted there was a typo. So, we requested the renewal to be sent. We just never received it to do it. We wanted to renew it. But basically, in 3 years, we've had 0 complaints. We have if you look at the ratings, we have a 4.9 star rating. Heather's done a great job. We've got the highest level of a superhost status on Airbnb, and it's just a 1-bedroom, behind our house. This is not like one of the non-owner occupied short-term rentals that, have all the problems in Nashville with the big parties and the trash on the street. We do have some of those on Greenwood, but that's not one of ours. So, basically, we want to renew the permit for the following reasons. One, we've proved that we're good operators. We've had 0 complaints and a 4.9 star rating on Airbnb. 2, this is an owner-occupied short-term rental that, respects East Nashville. We've lived there. We live on the property in front of the house, front of the rental. So it's a lot different than some of these non-owner occupied ones. 3, we really do rely on the income to make ends meet. It's been really important for us to be able to get that. And then, finally, we've expressed, we've always expressed interest in renewing, and our intent was to renew. It's just like we didn't get the email, so it was, I know the fault falls on us for not doing that, but it's difficult to renew when the only way you can do it is through the renewal that they send you that we never got. So we sent out all the letters to all the neighbors and, posted the sign, did all the things that we were supposed to do for the appeal. One of our neighbors wrote a letter. If I have enough time, I guess I'll read through it. It was pretty nice of him because we didn't ask him to do it, but he says, to whom it may concern, I'm writing in support of Michael Hoover's appeal. My wife, Jordania Adams, and I own 1304 Greenwood Avenue, where we have for 14 years. Mr. Hoover and his wife live across the street from us at 1307 Greenwood Avenue. They are excellent neighbors who take care of their property and respect their neighbors. Until I received the notice of their appeal, I did not realize the Hoovers had a STRP. That shows that they are discreet and respectful hosts who do not let their guests disrupt the neighborhood. Owner-occupied STRP hosts like Mr. Hoover typically respect their neighborhoods, unlike absentee STRP hosts. For example, the owners of the non-owner-occupied STRPs on the corner of Gallatin and Greenwood allow their guests to leave trash on the sidewalks and do not clean up. Mr. Hoover did not ask me to write this letter and does not know I'm writing this letter. I'm writing because he is an excellent neighbor and because I believe Nashville should promote and encourage owner-occupied STRPs. I respectfully urge you to grant Mr. Hoover's appeal. Thank you for consideration, Justin Adams. And that's really all I have to say. If you guys have any questions, shoot away.
Board members? Sure.
I think there was a typo that caused the first email to not, that you didn't receive that. And then on June 6th, looks like Mr. Osborne corrected the typo and then attempted to resend the email. Did you get that second email, or the sent second email, but first that you might have received?
I never did. I never did get the renewal email. I've gone through them. I don't know if it went to spam or what, but I never did receive I received the emails, all the ones that are on record, and replying that, we want to renew and everything, but I never got the one that we could actually do it.
Okay.
So despite that, and I'd like to highlight that the sending of the email or a letter or whatever form of notice you would get is a courtesy by the department. It is not required in order for your obligation to renew your permit if you wish to continue operating an STRP is not contingent upon Metro's sending of a notice. It's a courtesy that's sent. But despite that, the fact that they didn't send it, you were never under the impression that that excused you from complying with the code that requires you to have a permit in order to operate an STRP, correct?
Say that again?
Sure. The fact that you never got a renewal notice, did you take that to mean that you were then not required to have a permit in order to continue operating? Because we heard that there were 25 documented stays after your permit expired and the grace period had run. So were you under the impression that because you did not get a renewal notice, you were then not required, you were no longer required to comply with the STRP permitting process?
No, not so much. Those bookings, basically going back to we rely on the money.
Sure.
Those bookings were already, months booked in advance and they paid. So I think we just.
I'll just say one thing. I did know that it was expired, at that point, but I'd already had these people that had booked months in advance, and, I email with them back and forth, and they're so excited about their trip, and I just didn't really have it in me to cancel them because it's a dog-friendly place, and it's really hard to find in Nashville, especially in East Nashville, and so I didn't cancel them, no.
All right.
And we did change.
I did know it was expired, but I changed it to the 30-day.
Right. But these people that were, the 25.
They had already booked, just
right,
months out.
they were not 30-day stays.
No.
Clearly they couldn't have been. Right. Right.
No.
All right, thank you both.
You got the email that said, do you want to renew? You're still within your 30-day grace period, correct?
Yeah.
So you knew from that email you had essentially 30 days or less to renew your permit, correct?
Correct.
And you waited on another email to come, according to what you testified today, and you never got the email. And then you realized it in September and sent another email and said, hey, I need to renew?
Well, how can we renew? There is no way unless they send you a renewal email. You can't do it online. You can pay your property taxes and pay your water bill on the website, but you can't do that with the short-term rental permit.
But you knew you had a 30-day window or less, and it never came, and then it occurred to you again in September that you never got it? Why didn't you reach out to Metro before that 30-day time period and say, hey, I never got it?
Well, we'd already emailed them to send it, and we hadn't got it, so.
It's just kind of something, I guess we just forgot about it.
Okay.
It wasn't like an intentional thing to where we didn't want to pay dues. It was just oh, okay, well, we didn't hear back or anything, so.
If I could.
It wasn't intentional at all.
Thank you. If I could ask staff, Is it the case that an email is necessary to renew a permit, or is there a way to do that online or in person otherwise?
You can always renew in person, but the system did go in November of last year to online, and it does require for you to renew online that you receive a code from us in an email. I checked the records on the permit, and we showed the expiration on 5/30, the date of the permit expiration, and then we showed the extension until June the 30th. And our records indicate that when the email is sent, if it does not go through, it immediately kicks back to the system and it says CASR fail. And it has the date of the fail, which is always the date on which the email was generated and sent. And then it doesn't reach its destination, intended destination. And so it notifies our system, and it's noted, dated, and timed. In this instance, it does not show CASR fail until June the 30th, which indicates that the email went through, but the renewal information and payment were not received. And so that 30th is when the expiration was extended. And so on that date, when the follow-through had not been done, then at that point it failed. So if there had been a fail on June the 6th when the email was sent, on June the 6th it would have said fail. And it did not.
So what you're saying is, from what you can tell on your end, the email with the renewal code was sent to the...
Yes, it was. Now, it's possible that it went to spam. We have no control over that. We just send it to the email address that we have on file. And in the event that that email address is not correct, that's exactly why he received the initial email from Mr. Osborne, is because we do follow-up on that to make sure that we notify them within their grace period so there's no issue.
Yes, sir.
And at that point, he had corrected the typo, and the system generated and sent the email with the code again. And again, if it had failed, if it had not reached its intended destination, the same, within a couple of minutes of it being initiated and sent, we would have gotten a fail. And that was not the instance here. The fail did not occur until the expiration date of June the 30th. The date the email was sent was June the 6th. So we had no indication that the email did not make it to its intended destination.
Thank you.
Any other board member questions? If none, we will close the public hearing and go into deliberation.
I'm not persuaded to reduce the one-year wait period in this instance. They renewed the permit twice previously. The email clearly went through that there was a 30-day grace period. Mm-hmm. They responded to that email. It would have been reasonable of them to follow up and say, I didn't get it, if they in fact didn't get it. But what really gets me is the number of documented stays. 25 after the permit expired is a lot, but even if you take those first few out, 18 after that known 30-day grace period, and 7 after the notice of violation was sent. And I understand people have already booked, but that notice of violation is pretty clear.
Certainly.
And I'm not inclined to reduce the one-year wait period.
I concur. And
Would you like to make that a motion?
Yeah.
I move that we do not reduce the one-year wait period and they can reapply within 1 year.
Seconded.
All right.
We need a date certain. What is the date certain? I know we're not setting it, but
I was
just
about
so
to
it's
say,
clear.
I believe it's the date on the,
Staff, let us know.
yeah.
Am I?
I can just clarify that you're upholding the
Staff
other-
Holding the
recommendation.
staff decision.
Right. So it would be August of 2023?
I'll remake the motion in a minute.
There were 3 documented stays in the month of October, so the end of October of 2023 is when the eligibility would be.
I'm fine with that.
So I make a motion that we uphold the decision of staff, and we do not reduce the 1-year wait period with the ability for them to reapply for their permit in October 2023.
Is there a second? All in favor? Aye.
Aye.
Any opposed? All right, the decision is unanimous. Thank you all.
The third case before the board is 2022-42, 1632 Timber Run. Mr. Blakey Prost. Is the appellant here?
Yes.
Is there any opposition? Seeing none. This is for advertising and operating a short-term rental in violation of the Timber Ridge HOA agreement. And CCR. The CCR is the covenants, conditions, and restrictions. These are not available to the Metro Codes Department. We have to be provided with these by the Homeowners Association in order to be aware of any prohibition against short-term rentals. At the time the permit was issued, we had no awareness that there was an HOA agreement prohibiting, and the affidavit in the application package was that it did not violate an HOA agreement. This is governed by 2020-187. The decision of the board is whether or not the zoning administrator erred in the revocation of the permit. On May 31st of 2021, I received an email complaint from the owner-occupied that the owner-occupied STRP was not owner-occupied. The complaint was forwarded to me from Council Member Russ Bradford from a concerned constituent in his district. At that time, there was no short-term rental property permit for the property. No permit application had been submitted for the property. Metro's compliance contractor, Veronica's Host Compliance, had not identified any advertisements for the property. And I conducted an independent search on Airbnb and VRBO and found no ads. On June 1st of 2021, I emailed the results to Councilmember Bradford. On June 24th of 2021, an owner-occupied short-term rental permit application was submitted. The permit applicants were Mr. Prost, the appellant, and Ms. Braun. The proof of residence was Ms. Braun's Tennessee's driver's license and bank statement. On July the 7th of 2021, the owner-occupied permit was issued. On July 13th of 2021, I received another email complaint forwarded from Councilmember Bradford from a constituent. And this time, the permit had been applied for and issued. However, there were still no website ads. I reviewed the deed and found that on April the 20th of 2021, the Register of Deeds recorded a quitclaim deed that was generated on April 1st of 2021, in which 10% of the property had been deeded to Christina Ann Braun. I also found that Mr. Prost is a realtor with the Ashton Real Estate Group of Remax Advantage. February 1st of 2022, a hotline complaint was called in for the short-term rental property, listing numerous issues detailed below. The email is further down in your packet. On July 22nd of 2021, the first website advertisement was posted on Airbnb. July the 12th of 2022, the permit was renewed. July the 17th of 2022, a hotline complaint was called in for the short-term rental property, listing numerous issues. On July 17th, a hotline complaint was called in, a separate one, which stated that the short-term rental property was in violation of the HOA. On August the 5th of 2022, a hotline complaint was called in from the next-door neighbor at 1636 Timber Run regarding the entrance to their driveway being blocked by cars of people at 1632 Timber Run. On August the 11th, 2022, an email request was submitted to the short-term rental renewals mailbox by the association manager of the Timber Ridge HOA, of which 1632 Timber Run is a member, asking for the permit status of 1632 Timber Run. Administrative Services Officer Madison Neal replied, "There is an owner-occupied short-term rental permit for the property." The reply was, "Do they have to have HOA approval?" To which Officer Neal replied, "They do have to sign an affidavit agreeing that operating the short-term rental property will not violate an HOA agreement. If you are claiming that they are violating the HOA, then you will have to provide evidence." The association manager emailed the HOA declaration of covenants, conditions, and restrictions outlining the pertinent sections. Officer Neal forwarded them to me. I reviewed them and presented them to the zoning administrator. The pertinent section reads as follows. Article 7, use restrictions. H, business or home occupations, no trade or business of any kind, and no practice of medicine, dentistry, chiropody, osteopathy, and like endeavors shall be conducted on any lot or in the common area, nor shall anything be done thereon which may become an annoyance or a nuisance to the neighborhood. This HOA DCC&R went into effect on January the 12th, 2004. The zoning administrator determined that this prohibited a business of any type from operating in the bounds of the HOA. Also, on August 11th, I reviewed social media search and found that a blog where the property owners for this appeal are pictured writing about the new home that they had purchased in July. The revocation letter was sent on August the 24th of 2022, and by law, Metro is required to give 15 days of notice before the revocation goes into effect. Therefore, the effective date of the revocation was September the 8th of 2022. September 17 of 2022, the website advertisement was removed. September 21st, 2022, the STR appeal was filed. September 2022, there were 2 document stays. October 27th, 2022, the ad was reposted with a 30-night minimum stay. And we have received emails in opposition to the granting of the appeal, which are included in your package.
Okay, that concludes Metro's presentation. Mr. Probst, you may approach. And before we get into the presentation, are you represented by counsel today?
Yes, sir.
Okay. Well, first we'll ask you to identify yourself and provide your residential address, and then counsel may speak.
I'm Blake Probst, and I reside at 1632 Timber Run, Nashville, Tennessee.
Thank you.
Yes.
Hello, Vice Chairman. My name is John Bell with the Nashville Bar, and I represent Mr. Probst. If I could ask the administrator, where'd he go? Sir, is this, just for my clarification and understanding, was this revoked for because you determined the HOA didn't allow a business? So do I need to address these noise complaints? Is that a factor?
No, sir. What the board's decision today is whether or not the zoning administrator erred in revoking the permit based upon the HOA CCNR.
Okay. Why did you include all that? Don't you think it sort of prejudices?
No, sir. We always include we are. The Metro ordinance says that we are bound when we receive a complaint to notify the property owner of the complaint. Therefore, they become public record. Anything that's public record as far as a short-term rental property, it then is entered into the record on an appeal or a court case.
Okay, thank you so much for that clarification.
Yes, sir.
We appreciate the administrator. We appreciate this board. The thing that's happened here in this case is a disgruntled neighbor not wanting any kind of Airbnbs at all, and that's here in the record. Mr. Probst got his permit on July 7th, 2021. However, Ms. Mara Naylor, the origination of all these complaints, was reaching out in an email to Councilmember Bradford, concerned about how often they live there. Do they have ads? She reached out by email, which is also in your packet, identifying vehicles that were at the property. So she's out there at the window writing down license plate numbers F36078. Well, that's Mr. Probst's truck. The other one she cited was the Dodge Caravan. So she's sort of been at it on this since she received the letter which he sent out.
Applying.
Yeah, when she was applying. Now, she writes here in the email dated Tuesday, June 1st, 2021, 10:58, that she was informed by her neighbor by mail that he was converting the house into an Airbnb. Well, she later claims in another email that she never received a letter. So then Mr. Penn with Coes got involved because Councilmember Bradford forwarded the complaint to them, and it obviously, got some attention. However, in all the testimony here, Mr. Probst has never violated any regulation whatsoever. So it's about the HOA. So let's talk about that. Let me just say one thing, just as a point at a lot of the errors in this package. The social media post that the administrator found
was not me at all.
Mistakenly, it's not him. It's not his wife. It's not his kid. It's not his property. It's not the date he bought the house. That's just an error. So anyway, but let's get to the matter, and that is the HOA declaration. The HOA declaration mentions nothing anywhere in it about barring short-term rentals. That's not part of the case. What this is, a trade or business of any kind, for example, medicine, dentistry, chiropractic, osteopathy, like endeavors, shall be conducted on the lot. So he's renting his house out. He's not conducting a business. We've got 7 rental houses in the neighborhood that are for rent. So those are rental businesses. They pay taxes on them, and they're allowed. When Ms. Marr first reached out to the HOA, they said they were not barred. So they've come up to find this one business place saying that you can't operate a business when they're allowing rentals. That's the one that was
That's not me.
So the second thing I would say is to read these HOA CC&Rs, the administrator determined that it prohibited business. Well, that's right, but I don't think the administrator, I think he should have sent this to Metro Legal to get a legal determination. That's a legal opinion from the administrator that the HOA bars a business from any kind, which it doesn't. It allows for rental property, which is all he's doing is renting. So we don't think that the legal interpretation by the administrator that prohibiting any business of any kind when it's talking about doctors, chiropractor, medicine, those kind of things. We understand that where people are coming every day into a business. Yeah, that's barred. But not when people are renting houses in the HOA. That's not barred, and it's a wrong legal opinion to state that this clause would bar STRs. So, based on that, we asked the board to approve our appeal. Going back to the complaints and so forth, I would mention that in the advertisement for the property, which is in your packet, because the same lady stated that it wanted bachelor parties. No, that's not what it says. Hey, y'all, welcome to our family-oriented HOA neighborhood, 4 bedrooms. It's in the package. They also in the package are the reviews. They've got a 4.9 review on every review, 38.
I'm sorry, Mr. Bell, I believe that's your time.
Can I say anything?
I'm afraid the time has expired. I believe we did, or if I'm not mistaken.
Yeah, they did.
Well, we can certainly do that now. Is there opposition present in this
There's
case?
no opposition present.
There was no opposition.
Okay, that's what I
That's why
thought.
the 5 minutes.
Okay, right.
Can I get 5 minutes?
Unfortunately,
5
no.
minutes. Just hang
Yeah,
on a
no, the
second.
five minutes was both of
I got something
yours.
to say.
I have a question for Metro. The 3 logged complaints in the hubs that we've got, do we have any way to know? I can tell 2 for certain are from the same person. Do we have any way to know if the other came from a different person or?
Included in your packet, there is a hotline submission on which the complainant is named. And there are emails in your packet supporting the complaints that were listed in the summary.
This is an owner-occupied permit, correct?
That's correct.
Actually, I have a question for Metro as well. The certification portion of the application is a bit unclear, and I want to make sure that I'm reading it correctly. I believe it says, this notification confirms that no homeowners association agreement exists governing the property applying for a short-term rental property permit. Is that correct? Did I state that correctly?
You'll have to give me a moment to
Sure.
reference that document.
Sure. I believe the word that I'm unclear on, I believe that says governing after exists, but I'm not sure. Yeah.
Correct.
Okay. So, Mr. Bell, Mr. Probst signed that declaration in the affirmative that no such agreement existed. Is that correct?
Where is that document? That's in his application?
That's at the end of the application, if I'm not mistaken.
Let me just find it, make sure I understand what you're...
No restrictions?
Okay, so.
There are no restrictions.
This application confirms that no homeowners association
Right, and then there's an or.
governing or, and then
Right.
the second one says, it's
At-
very blurry, that's why we're.
No,
Yeah.
you're fine, you're fine. I checked the HOA bylaws before I did this.
Hold on 1 second, that's not the.
It's on your screen.
Okay, great.
Attorney Bell.
I don't know that it's any clearer,
Attorney Bell.
unfortunately.
Attorney Bell.
I thought it was asking
So
me.
it's, to me,
I took it as do not restrict.
well, I'll say that first.
Yeah,
The HOA doesn't restrict
Yeah,
short-term
that
rentals.
does not restrict rentals.
Hang on a second. Also, I would tell the board, the HOA is a remedy. They can bar STR rentals tomorrow with an amendment to their governing documents. It's not that
There's two rentals on my street.
my concern is it is absolutely true that there is an HOA governing the property and its
I
permitted
can't find
uses.
that document, so.
I see it, but
Well, the actual,
read it
I
all.
believe there's a citation to the very section that is alleged to apply to these proceedings in Metro's summary. Are you denying that?
Let me ask you
That
this.
purports to govern the-
Will
that
you
purports to
do me
govern
a
the operation
favor
of property?
and read me what he checked on his application, since I can't
Yes,
find
he
that?
checked, or this notification, I believe that says confirms that operating a short-term rental property will not violate any homeowners association agreement or bylaws. Condominium agreement, covenants, codes, and restrictions, or any other agreement governing the limiting the use of the proposed STRP property.
That is a correct statement.
Okay.
The HOA does not bar STR.
Understandably, that is his belief as to whether that section applies to his operation of the home as an STRP. However, the other statement is also true. There is an agreement that governs that. It would be the HOA agreement that we're discussing right now.
I misunderstood.
Okay.
Well, the point of the answer was.
I would have checked yes. I mean,
You're fine.
I would have.
Tell him. The point is the HOA doesn't restrict STRs. I understand what you're saying about, is that a space where the HOA goes up above there?
Well, that's a space where he can certify if that statement is in fact true.
Messed up.
And there is a document that governs his use and disposition of that property.
Okay. He certified that it will not violate the homeowners association agreement. That's a true statement.
So see,
He
I knew there was a homeowner.
He certified that it wouldn't violate the bylaws. That's a true statement. He certified that no condominium improvement, no, sure is. But every word in that statement that he certified is true.
Okay.
And it does show that I knew that there was one governing it. I guess I just misunderstood. It's my first time filling out. I mean,
Okay. So, and I'm sure you'll correct me if I'm wrong, but Title 66 of the Tennessee Code governs leases of residential property, ordinary leases of residential property, correct?
Correct.
It does not govern short-term rental properties, correct?
And what is that?
It does not govern STR. Title 66 does not govern STRPs, to the best of my knowledge. Would you agree?
I'd have to look at Title 66.
Okay.
Hang on a second.
To the best of my understanding, it does not, and that's why there's room in the code for Metro to govern these particular iterations of property that you can do things with. And
Right.
so that's why I'm having a bit of trouble with your interpretation of Article 7 of the HOA agreement that says no business of any type.
Well, if they were allowing businesses, all right, you agree he's renting the property?
I agree that he is complying with the Nashville short-term rental appeals properties code sections, yes.
Well, what I'm saying is, we've got emails where this lady asked HOA if it barred them. They said no. He checked before he bought it. They said no. And then in this case, they because the part of the CCRs that govern rental property, and we're talking about does the HOA bar short-term rentals? That's the question. It's not, and the answer is, there's no language in the HOA covenants and restrictions that restricts short-term rentals.
It says all businesses.
Well,
and that was my point originally.
I understand that. I appreciate that. But my question is, how can I live next door and rent out my house for 30 days? Okay. And that be an allowed business, and me live next door and renting my house out for less than 30 days because I've gone through all the steps to get a short-term rental.
To the best of your knowledge, does one actually have to obtain a business license in order to rent out?
It's still a business and profits, a long-term
It's a
rental.
it's a
There's two
business
long-term
according to
rentals on my
you, but
street.
No, it's a business.
the question that I'm asking
They pay
is,
taxes.
does one have to obtain a business permit in order to rent out a part of their house pursuant to the terms of Title 66?
The reason that long-term rental and short-term rental are businesses is because they are intended to generate a profit, and they make a profit. They do require a Davidson County business license, and they require reporting to the IRS, your profits and losses, because it's a business.
Okay, so if I wanted to rent out my house now, subject to the terms of your alt under Title 66, I would have to obtain a business license to do that.
I don't know if you'd have to obtain a business license. You would have to file as a sole proprietor to the IRS that you're operating a rental business and pay income taxes on the income or write off the losses from that business. It's a separate form in the IRS, just like if you were doing Uber, or it's just another business that you're doing.
Okay, so in effect, your argument,
But an Airbnb permit, I applied for an Airbnb permit, not a business license.
so in effect, your argument is because they're doing it, we should be able to do it too, not that it's not a business.
No, my argument is,
A business license.
I would encourage you guys to not talk over each other.
Yeah.
You've hired counsel. I understand you have some things that you want to say, but I think we're muddying the waters here. So let's just talk one at a time so that we can get our points across.
I think the HOA wanted to restrict STRs, which they still can do today. They would put that in there. They wouldn't try to find some obscure old clause that was in there. Clearly had nothing to do with short-term rentals. It was about businesses that had incoming and outgoing clients all the way during the day, causing disturbance in the neighborhood. He's just renting his house out. They're renting their house out. My point is that to determine whether it's a business or not, you got to go outside of that and make these arguments that, well, that's a business. They file a business tax return on it. This is a business. They file a business tax return on it. I don't see anywhere in the statutes that having to get a business permit.
You don't get a business. I'm sorry.
You're fine.
Yeah, you don't get a business license, though.
You got a question for
You don't get a business license for STRP.
To me, it seems you're stopping before the main part of that definition. Because that definition says no trade or business, et cetera, which may become an annoyance or nuisance to the neighborhood. According to these documents, there are a lot of people that say, and it's an annoyance and to the neighborhood. Well, you're saying there's one.
There's one, sir. There's one who tried to get it kicked out 4 months before he got his permit.
I'm just saying.
So I'm saying I'm saying the board can't rely on
your definition of a trade or business. You're not continuing on. It says which may become an annoyance, and I can see where the zoning administrator would say, "Hey, he's getting all of these complaints."
I just happen to disagree with you. They're getting one complaint from one person that has conspired with the council member there. And with this document, it's in the package. She sent an email right after he bought the house talking about all the things she's accused. So you can't, the board, I don't see how the board can determine that it's a nuisance when it's one person who's been against it from the very beginning, and we've got a documented track record of that person's standing at the window writing license plates down, which is a license plate to his car.
Okay, I have a question for Metro. Is Metro's ruling because there cannot be a business operated? Or was Metro's ruling because there cannot be a business operated and or there was a nuisance? What's the reasoning?
The reasoning was, of the zoning administrator, was that it is a business.
Okay.
Sorry.
Any other board member questions?
I have a question. So this The documents that supported the permit were this Ms. Braun person.
Yep.
What is your relationship to Ms. Braun?
That's my fiance.
That's your fiance?
Mm-hmm.
Okay.
We have a 2-year-old baby boy. That's our boy that they've talked about.
Okay.
That's my little boy.
Thank you.
I mean, I've got plenty of pictures. I actually brought a lot of pictures because I read through this myself, and they were saying we don't live there. Nashville's a highly traveled place. I do real estate here for 8 years, and so my house stays booked. So, but I mean, I have we've spent Christmas there, we've spent every holiday there. I have tons of pictures that I've brought.
And it's currently listed for 30-day rentals?
When this occurred, I followed all the rules to get a permit.
But you live there and you're renting it out for 30 days at a time?
I went because I knew that you don't have to have a permit for 30 days, so I went and switched it to 30-day rentals. So that's what's so
Is
crazy.
it challenging to host a 30-day rental in the home you live in?
Do what?
Is it challenging to host a 30-day rental in the home you live in?
Yeah, it is. It is. But with the pandemic hitting, I'm not selling the homes I was last year or the year before. I think I've had 2 closings this year, which, I mean, none of that matters. But, yeah, I'm born and raised. I'm a Nashville native, born and raised here. And my parents live down the road, and they have a house, and we stay with them to, when we can rent our house out.
Thanks.
When you file your taxes, what's your residential address that you put on your taxes?
I hadn't filed this year. Last year, I bought that house. My last year, it was my other house, the house I was in before.
Okay, and you bought this house in 2021,
Yes.
correct?
Uh-huh.
And in April 2021?
Yes.
Okay.
Yeah, I mean, for me, I host Airbnb. I do real estate. It lets me meet clients. My guests turn to clients. I love to give people recommendations. I've made many friends out of these guests that come here to see our lovely city. These people come from all over.
The public hearing is closed. Mr. Probst,
I don't host
opportunity.
parties.
I understand.
I'm very strict on who I rent to. I turn people down.
I understand, but we've made clear the public hearing is closed. If you're asked a question, you're more than welcome to answer, but if there are no questions, you're not permitted to speak.
I got you, yes, sir.
Okay.
If there are no other questions, we'll close the public hearing and enter into deliberations.
I think these are very poorly written HOA covenants. I think that there is ambiguity there.
I agree.
I think that arguably they do not outright prohibit short-term rentals. I am not persuaded by this document, which is the affidavit. To me, that is very clearly an either-or sign which one is applicable. I think he signed the one that said, I don't think I'm violating it, or Ms. Braun did. I think that, as pointed out by council, the HOA has a remedy if they want to amend their documents to prohibit the short-term rentals. Metro did not make this determination because it became an annoyance or a nuisance. They made the determination based on trade or business of any kind, which I think is ambiguous. At this point, and I'm happy to discuss and be persuaded, but I'm likely to support a motion that there was an error.
I can see it either. I could easily argue either way, which means I would be less likely to vote in favor of finding that the administrator did not err.
Yeah, I'm inclined to more toward Mr. Bond's position at this point and not seeing an error. The HOA is ambiguous, and I think that would, in my mind, make it more inclusive of different types of activity that could be construed as businesses. The argument from council was that the long-term rentals in the neighborhood are also businesses, and maybe that's a case for the HOA folks to cease the operation of those long-term rentals as well. But that's not the question that's before us today. do we find sufficient evidence that the zoning administrator erred in determining that this was a business operating in violation of the HOA? And I'm not convinced that there is enough evidence that the zoning administrator erred personally.
To be clear, I'd also like to say that I find the complaints to be compelling. And if that were factoring into my decision, I would be making a different decision. But that's, as council has pointed out, is not the question that's before us today. But those complaints would be compelling for the future.
Any other discussion? If none, is there a motion?
I'll move that the zoning administrator did not err.
Are you sure that that's the motion? Or do you want to find that the zoning administrator did err based on the discussion we just had previously? We're denying relief if the zoning administrator did not err.
I don't believe there's sufficient evidence to determine that the zoning administrator did err.
Okay.
I think there's a differing opinion.
Gotcha.
Do you all have some insight before we put a motion on the table?
I don't have any specific insight, but I do think I have what I believe is correct, or what I think I have an opinion, but I don't have anything further to add to persuade anyone.
And can you repeat what you said, what your motion was?
My proposed motion was that the zoning administrator did not err in determining that the HOA prohibits.
Did not err?
Gotcha.
Did not err.
Perhaps it could be rephrased in terms of upholding the determination of the zoning administrator.
My proposed motion is to uphold the zoning administrator's determination that the HOA precludes operation of businesses and therefore short-term rental permit in this case.
Okay. Is there a second?
If folks have thoughts, I mean, like we're in deliberation, so let's hear it, please.
Well, I go back to what I said. This definition says no trade or business, and then it says which may become an annoyance. Can't operate. Well, I agree it was an annoyance, but that's not why the permit was denied.
Right.
It's because it's a trade or business. And I say trade or business, it seems to me, is I agree with the gentleman down there that it is a trade or business that should be allowed. I would have read this if I were applying for a permit. I would have said no. It doesn't go against HOA, because as long as I'm, operating responsibly, although we're not.
I guess for me, I could argue it either way, because in 2004, when this language originated, there was no such thing as an STRP. So you can very easily argue, and maybe compellingly so, that it could not have been within the HOA's contemplation. These types of units would be included in the definition of a business. I think you could also make some pretty compelling arguments the other way, which is a lot of what my line of questioning was sort of getting at. I don't think that the affidavit is particularly well structured. I do think that there should have been an answer on the first one, and I think if there had been a representation on the first one, we might have cause to say it's denied, it's upheld because you made a false statement on your application. But given those two things, I just can't comfortably say that the zoning administrator did not err in making their determination. So, is there a second for Councilmember Parker's motion?
I second.
Okay. All in favor?
Aye.
Aye.
All opposed? Nay. The motion fails.
So we need to make countermeasures.
Yes, and I would move that we find that the zoning administrator did in fact err, and that there was no violation of the HOA language as written. All in favor? Aye. All opposed?
Aye. Or no.
All right, it looks like the ayes carry for that motion.
Do we need 4 votes for a motion to prevail?
No, a majority of the quorum.
Yes.
Thank you.
Thank you. No. You may be excused.
These new HOAs, they say no rentals in there.
Have a great rest of your day, sir. Yeah, thank
No
you.
rentals, no extra ERPs.
That's great. That's great.
Man, thank you guys. Buy a lottery ticket. Y'all are awesome.
Oh, my God.
The next case before the board is case 2021-43, 1016 Alicia Avenue, Newbrook, Olmsted, the advertising and operating a short-term rental before obtaining a permit. This is an SP zone district. SP stands for specific plan. Each time that an application for a short-term rental property is submitted in an SP zone, it has to be reviewed by planning. Planning reviewed this and determined that owner-occupied short-term rental permits were allowed in the SP. And this is governed by Bill 2020-187. Excuse me, that must be a typo. One moment, please. No, that's correct. There's no discretion less than the 1-year probation to apply for a short-term rental permit. In this case, the decision of the board is whether or not the zoning administrator erred in denying the permit based on the evidence that the property was advertised and operated as a short-term rental property prior to obtaining the permit. On September the 8th, 2022, Program Manager Robert Osborne reviewed an email sent to the STRP questions at Nashville.gov mailbox from a neighbor of the appellant's property who had received a neighbor notification letter. Councilmember Parker, the district council member, was copied on the email. Mr. Osborne replied that the application had not yet been received, but all applications are carefully reviewed. There was some initial confusion about the ownership due to the fact that the property was quitclaim deeded from Capital Investment LLC to the appellant, Mr. Olmsted, on September 26th of 2022. Additionally, Councilmember Parker forwarded an email that he had received from another neighbor. On September the 14th of 2022, Gronica's host compliance tracking had 2 website advertisements posted on this date, one Airbnb and one VRBO. On September the 26th, 2022, the application for an owner-occupied permit was filed by the appellant. On that same date, 1016 Alicia Avenue was quitclaim deeded from Capital Investment to Mr. Olmsted. On September 27, 2022, the application was being processed by a zoning examiner, Robert Osborne, who found that host tracking for the property recorded 2 website advertisements had been posted prior to the making application. The Airbnb had 2 documented stays for September. The VRBO ad did not have any reviews. The permit was denied based upon the evidence that the property had been advertised and operated as a short-term rental property prior to obtaining the short-term rental property permit. October of 2022, Gronica's host compliance tracking recorded 4 documented stays for October, but I was unable to substantiate that based on ad reviews. September the 30th of 2022, short-term rental appeal was filed. On November the 15th of 2022, both website advertisements were removed. On November 29th of 2022, the Coast Department received 2 emails opposing the appeal, both of which indicated that the required short-term rental appeal notification sign had been removed from the property on appeal. I made a site visit at 1:34 p.m. and saw no sign. I took a photograph of the property. The emails and photo are included in the end of the hard copy provided each board member.
Good afternoon.
Is there opposition to this case? We do have opposition, so it'll be 10 minutes.
Which one of you is Mr. Omosov?
I'm here just to make the opening statement and then clarify a couple things.
Who are you?
My name is Aziz Ashraf. I'm with the Capital Invest. Because on the form that you guys have, it states my name on there as well, Capital Invest.
Right.
And I actually received one of the complaints, which obviously was prepared with the insider information, was a gentleman right here, council member, and then also the lady stated all the information that's, first of all, a lot of them falsified. You guys have that information. Okay. And then a lot of them is a private information. So
okay, thank you. Thank you. Thank you. Counsel, I'm not inclined to allow this gentleman to speak since he's not a legal representative of.
My name is a Capital Invest.
Hold on just a second, sir. I'm speaking. Again, Capital Investment is not a named appellant in this matter, although they are mentioned in the complaint.
As long as it's not,
I'm not inclined to let this gentleman speak on behalf of Mr. Omosov or on his own behalf.
Who's the owner? This person right here.
Mr. Omosov.
Yeah. Yes. I living is for 2 years more.
I believe this issue came up.
It did, came in the last meeting.
And actually, my understanding is that it's not necessary. I believe it could be a representative. It doesn't necessarily have to be a representative.
Okay. All right. In this case, then, the balance of that, this is not, however, a person who's acting as an official representative. So I'll let you two decide how you want to divide up the time. You'll still have 10 minutes, as will the opposition to speak.
And for clarification, I think the last time this came up, the owner was not present.
That's true. That is true. And thank you for refreshing my recollection on that.
And this is the first case where we have opposition present. So you have the total of 10 minutes, so you can retain some of your 10 minutes to address anything that the opposition brings up during their 10 minutes. Is that correct, staff? I'm hearing that that's correct. So you may want to reserve 2 or 3 minutes or 5 or whatever you choose for after opposition speaks.
But please note that you're reserving the balance of your time once you're finished speaking, if you have time remaining.
So I would like to start.
Well, before you do that,
yes, sir.
We'll need Mr. Omosov to identify himself and provide his address.
Okay. Yeah, so my name is Norman Kulmasov. I'm living for 1016 Lichin Avenue, Nashville, Tennessee.
Okay.
For more than 2 years. I worked for his Capital Invest, and they helped me to build for house. So everything.
Okay. I'm having a bit of trouble understanding. If you wouldn't mind speaking up a bit.
Yeah, but my voice is a little bit. It's for I'm full,
I understand.
So I living for 1060 Lichin Avenue for still living, but she can approve to my neighbors. She came to, but I've got this from him message to yesterday, and I'm working with Capital Invest too.
Okay, very good.
So, okay. My name is Aziz Ashraf. I'm with the Capital Invest. Okay. And you guys, I think, have the hard copy of the email that was prepared by the...
Mr. Vice Chair, we need all people that address the board to state their name and address.
Yes, thank you. Thank you, Mr. McBroom.
Aziz Ashraf, and I own and operate Capital Invest, LLC. And I have several addresses.
but my main address is 728 Crestmark Drive, Mount Juliet, Tennessee 37122.
Thank you.
So the only reason I'm actually here is I don't live in that house, and that neighbor who's complaining can prove it, who is the witness of this council member brought it up, but he is the person who lives in that house, and we built it for that gentleman, and ever since he's been living in it. But they prepared all this information to provide for you. That's against me. They assuming that it's my property, which you can, that lady, Whitney, earlier specified to this gentleman who was sitting here, if he did the tax returns with that address or paid the taxes. This gentleman right here does the tax returns from that address and pays the property taxes for years from his name. So I'm not even involved, and I'm not really sure whatever they're finding against me supposed to work out or relevant for his case of trying to get a short-term permit. So I think my name should be completely removed, and the case should be considered solely depending on this gentleman right here. That's the only reason I'm here. I wanted to make sure, clarify that I shouldn't be involved in any part of this thing.
Mr. Ashimov did not file the appeal, so he is not involved. The only reason that his company appears is because on the date that the appeal was filed, that was still the owner of record, because the house was quitclaim deeded on the same day and had not been recorded.
Right, and thank you, Mr. McBroom. And as such, you're not entitled to request any relief from this board.
Yes.
And you were allowed to speak. You were allowed to speak on our assumption that you were speaking as a representative of this gentleman here. So if you're speaking on your own behalf, you may be excused and return to your seat.
Okay.
Thank you.
The email as well, because email represents a lot of falsified information about me.
That'll be all.
And it shouldn't be.
That'll be all.
All right.
Thank you. Mr. Omosov, you may continue if you have more to say.
Yeah, so I living for 1060 Leash Avenue for 2 years. So I want to do for Airbnb for short rental because I have some problems for my health to help to my bill. I'm listed on the liver transplantation from Vanderbilt. So I try to legal side do for Airbnb, but it's for I did for open it first. Is for I know it's my fault. First is I open it for Airbnb and VRBO is for same times I did it ready for everything, and I send it for Mr. Osbury for all applications for my documents, and they say it's for it's a website on list. I just stopped it for this, but it's for I was means for fuse reservation over there. Then I didn't cancel this one. Yeah, I knew. I just keep it for, but I take out for website for everything, and I stop it. I wait till for I didn't never open it for again for release it. So it's still no listed for me, but just I service it for couple reservation over there. Then I stop it. That's it. I very apologize if you guys doing for better for help for this take it for short rental permit. Will be great for to help my bill for health, But I'm still over there. Sometimes it's for going for my friend living for his house, but I'm living still there. When it comes for reservation, I'm get out of the house. So my kids, 2 kids, and my wife, for everybody we living. My children is going for school over there too, every morning. So I don't have any for complaint for you guys.
Okay.
That's all.
Okay. Would you like to reserve the remainder of your time for rebuttal?
Excuse me?
Would you like to reserve the remainder of your time for rebuttal?
Yeah.
Okay. How much time does Mr. Omosov have? 6 minutes and 9 seconds. Okay, you have 6 minutes and 9 seconds. We'll have your opposition come forward. So if you'd like to.
She's coming?
Yes. Good afternoon. Thank you for joining us. If you'd like to provide us your name and address.
Yeah, I'm Danielle Maygard, and I live at 1012 Lishy Avenue, Nashville, Tennessee, 37207.
Please go ahead when you're ready.
Yeah, I prepared this whole statement in a big timeline that the Coast Department went over because I didn't know how this operated, so I'm going to skip around from my speech, but to help for some helpful things, I know Aziz isn't here anymore, but until just recently, he did pay the taxes on the tax record the last 3 years. His name is on as paying the taxes. So basically, I came here, my neighbor is an educator, and so she sent a letter too I can read in opposition. I realize now that you guys are we're doing it based on did codes make a good decision, so I'm going to cut out part of my letter. And also I will say, for clarification, I did send an email that Aziz is referencing, and I did get them both messed up. Aziz's name has been on the property this whole time. I thought Mr. Nurbeck here, who has been living next door to me, yes, and I thought you were Aziz, so I apologize. So the original email is a little bit of a mix-up on that, and so I've corrected that in my speech. Basically, Capital Invest, I should say, I know that Nurbeck is an associate and or partner with Capital Invest, but I'm not sure all of it. But Aziz is known for making very unethical business decisions. And the issue with the STR started in August of this year. It was noticed when they moved out of 1016 Lishy Avenue, having lived there since 2019, in the beginning of August. And then August 31st, my neighbor, Samantha Singer, who lives at 1014, received a certified letter notifying that Nurbeck Umasov was applying for the SDRP. I did not receive the certified letter despite living 2 doors down. She's the one who reached out to Codes in opposition, and Mr. Robert Osborne in Codes informed her that there was no application and that the person sending the letter was not even the owner of the house, creating another conflict that needed to be investigated. It was then realized by all parties that this letter was false, and it attempted to lie to neighbors that they were following the rules when they were in fact not. Then on September 19th, I noticed that there was a large group leaving the house with suitcases, confirming our suspicion that the entire house was already being rented out despite not applying for the STRP. I was finally able to find the listing on Airbnb where it listed the entire house, including photos clearly showing there was no one living at the residence. I sent it to Mr. Osborne, where he determined it went up on Airbnb on September 14th, and at this point he still had not received an application. On September 26th, it was quit claimed for $1, which Mr. Aziz thinks that Councilmember Parker told me, but it's not. It's on the deed. I pulled it from public tax records, which is interesting because he attempted to sell the house for $1.2 million in June, and it clearly didn't sell, so they took it off the market. And so at this point, it can be assumed that Mr. Ashraf and Mr. Umlasov are working together to run this illegal STR operation. After Mr. Umlasov was listed as the owner, Mr. Osborne then received the application, but then denied it, as we know. And then on October 15th, I was walking to get a coffee, and at the same time, a new group of residents left the house. And I asked them where they booked it, because Airbnb, it was blocked out, and they said VRBO. That's when I found the VRBO listing and sent it over to Mr. Roberts. And they actually gave me their number and contact information if they needed to make a statement saying that the owners did not live there and it was completely empty. And they were able to rent the entire property. And then on November 14th, as Mr. Feltz called me about evidence on enforcement. And then that's when I got a letter about the denial, but Ms. Singer at 1014 did not receive the letter of appeal. Since this was denied, it has been rented out every weekend since, including this 2 different parties this last weekend. Ms. Singer and I have several photos and videos that we're happy to share of different rental properties, along with both of us having to call the complaint line due to loud partying and disrupting our sleep in the middle of the night. And since this appeal process has started, he has failed to, Mr. Umlasov has properly failed to display the signage required to notify neighbors of the appeal and the right to speak out for or against it. And it was only noticed this last weekend when Ms. Singer was attempting to identify the second party and if they were different than the first party. When we noticed that the sign was tucked along the side of the house, I, being a justice warrior, went over and moved the sign to be visible neighbors so they could be made aware of what's happening. On Saturday, we noticed that the sign was removed and put on the porch, completely not visible. I again went over and moved it back into place just to see what would happen, and a few hours later, the sign was removed and is nowhere to be found. I do have photo documentation of this as well. In addition to 1016 Lishy Avenue, Mr. Osborne has informed me that Mr. Ashraf and Capital Invest have routinely operated short-term rentals illegally in the past, and in fact, Mr. Osborne has taken him and his associates to court before regarding a property on Trutland Avenue in East Nashville. And then basically all I'm about to say, which no longer applies to you, but Councilmember Parker is well aware of the nuisance that Capital Invest does cause in District 5. And then in addition, I have printed 8 copies because I read the whole code on how a meeting goes of not only my statements, but Ms. Singer's statements and the email that Mr. Ashraf, Ashraf sent to Mr. Umasov. So my email got forwarded to Mr. Umasov, which then forwarded it to Mr. Aziz. And Mr. Ashraf said in the email, Unuzbek, brother, take a look. It's all written down. It's a polished story. I wonder if it'll be salty tomorrow. And I'm not prepared to bring salt. I'm just trying to tell the truth of what's happening. That is very much a party house, and the rules are not being followed. And I'm happy to read Ms. Singer's statement if needed.
If you have the time, you're welcome to.
Okay. How much time do I have left? Okay, I'm done.
Okay. So I just got to look through that. Thank you. Mr. Omasov, you now have the balance of your time to reply.
Okay. Reply, but she saw it's for some of the gases for my house. I told it's for when I before applied, I open it for be ready for when I get it for short rental permit. That one is for all my booking stuff, but it's for when I take it from Osborne for mail. He said it's for you have to stop it for apply it because it's you no approve it. Then I stop it, but I didn't open it. Well, this one is I know, but some of the capital invest. I told him it's for when I come for Nashville is for capital invest tried to me buy the house, but I bought this house for old house. Then we want to remodeling that house, but it's for we can't. Then it's for more expensive for building. And the capital invest he said is for if you're gonna. I can build it for you, but you can still living. So I say, okay, I'm gonna help to you, but I'm leaving when his house was being ready. I live there till paid for my bill. I paid for my bill for everything for Capital Invest. Then Capital Invest they give it. I approved, put for my name. You know, that's all. For other, this Capital Invest is for. Sidewalk is everything. I don't know, so everything, you know. I'm own my house. That's it. Mm-hmm. And I'm still living. That's it.
Okay. All right.
I know. When I came is for this new house, she came my house too with friend. I give it for her cake.
Hold on. We can't both speak.
Yeah,
we cake.
We did celebrate with together. I don't know. It's for nothing wrong.
I got it. So have you truly completed your statement? Because once you've completed your statement, then that will be your last opportunity to speak, and the board will have questions for you. You'll be able to answer those questions, but you won't be able to speak on your own behalf. Okay. Board member questions?
Mr. Vice Chairman,
yes.
There was a mistake made on the timing. Ms. Maggard still had 4 minutes remaining. So if she would like to read her neighbor's opposition into the record, she has the time if you will allow.
Okay.
I'm just going to read the last part. The first part is the original email that she sent to Codes, which is on record.
Okay.
She said, additionally, I would like to share a bit more information on how things have progressed with the property, which is my direct neighbor. Despite not having a permit, I've recorded close to a half a dozen videos of short-term renters that are using the house at all hours, including one group that woke up my children at almost 1 a.m. on a school night. Almost all renters have been large groups, understandably given the size of the home, and many have been loud and disruptive parties while staying in the house. The recordings I have are just a few that I've been able to grab video of, as there's been renters coming in and going every week since we first reached out regarding the illegal renting of the property. As we head towards tourist season, I'm fearful of the disruptions that will be caused by large parties and groups during the school year and the upcoming member. It's my understanding that he is requesting an owner-occupied STR permit, and I also can confirm that no one is living in the property. I see the previous owner's documents when they are visiting to clean the home between renters. I do not believe that he's intending to live on the property nor rent only part of the home, as online postings listed on multiple platforms include entire multi-bedroom home. I'm beyond wary of non-owner occupied rental next door, given the ages and schedules of myself, my young children, and my neighbors, most of whom are long-term residents on the block. Once I finally found the appeal notice hidden on the far right corner of the home, it was then moved to a visible place in front by my neighbor Danielle. After it moved to the front, it seemed that the owners of 1016 Lichy chose to remove the sign and not post it at all, a clear sign that they're choosing not to play by the rules or have regard for those around them. Our neighborhood has already had some multitude of STR properties available for those wishing to stay in Cleveland Park, and I see no need to add an additional rental property at the cost of the well-being of the neighborhood residents. Between the owner's consistent violations across the properties he owns and the lies perpetrated through the process of 1016 Lichy, I strongly ask that you deny the permit requested and allow us to maintain our block as a welcoming and quiet place for veteran and new Cleveland Park residents and families.
Thank you. Okay.
Mr. Vice Chair, this is an unusual circumstance, but Mr. Olmazal still has 425 if he goes to rebut.
Yes, I was about to invite him to use the balance of his time. If you have a sir rebuttal to her statements, then you're welcome to use the balance of your time to do so. If not, we'll move into board questions. Do you have anything more?
No.
Okay.
No, that's
all right. Board member questions?
I've got one. Mr. Olmazov, so just to make sure that I'm clear, so when you became aware that you had been advertising without a permit, you had some bookings already scheduled out, and you did honor those bookings?
Yeah, I didn't cancel it because I locked up. It's for website, but it's for some of the old people reserved. They came.
Okay.
But I just looked up. There's no more reservation. A few reservation was being is for they came. That's it.
I don't have any questions.
I didn't know it's for like quick reservation.
Okay, well, if there are no other...
Can I ask one quick question?
Oh, yes, please.
Pardon me. I noticed on the appeals board document, this one here, it has your address at 728 Crestmark Drive in Mount Juliet.
728 Crestmark, Mount Juliet. Yeah, okay. What?
Who lives at that address?
It's Aziz Ashurov.
Oh, that's his address. Okay.
Yes.
All right, that's part of the confusion. Okay, thank you.
Once we get to deliberation, I have something I'd like to say, just because my name was brought up several times.
Right. Okay, well, if there are no other board member questions, we will actually close the public hearing and move to deliberations.
Thank you. So I just wanted to, I have had some interactions with as the council member for the area with Capital Invest, helping constituents deal with issues related to Mr. Asherov's properties. But what's before us is Mr. Olmazov's appeal, not Mr. Asherov. So I just want to make that clear. And again, there's been a lot of discussion, I know, about some other issues, but let's remember that we are here because this property was advertised and operated without a permit. And I suspect that some of those other issues might come up in the future, but today we're looking at advertising and operating without a permit.
Right. Yeah, I agree that we should definitely focus the discussion, and I'm not inclined to believe that the zoning administrator erred here. I think there was just an admission that there is advertising and operation without a permit. So I don't know that we have no discretion to grant any sort of relief. So I would make a motion that we find that the zoning administrator did not err and deny relief accordingly.
Second.
All in favor? Any opposed? Mr. Olmazov, your request for relief is denied.
Okay, thank
you. I'm sorry?
I'm just curious, how does I haven't been to one of these before. When is the public allowed to speak, or what is the procedure?
We don't normally provide for public opportunity to speak to the board absent, being opposition in particular or support of a particular case that's being heard.
If you have a specific question, you might be better asking staff. Right here at this table, if that's okay, y'all.
Did you need to put these letters into the record? I printed 8 copies, but I don't know if you need copies.
You can just give us one.
Okay.
Thank you. next case before the board is 2021-44. This owner-occupied permit is denied because the short-term rental property is not the principal or primary residence of the owner and permit applicant based upon the judgment of the zoning administrator's designee. This is an R6 and only owner-occupied permits are permitted. This is governed by 2020-187, and the decision of the board is whether or not the zoning administrator erred in denial of the permit. The appellant is Dr. Rachel C. Rome for this case, and Dr. Rome's husband is Dr. Rodney E. Snow IV. Based upon our research. September the 1st of 2022, the permit application for 1509 Cahal Avenue was received by Administrative Services Officer Madison Neal. It was denied based on the evidence that follows. March the 20th, 2014, 203 Hillwood Boulevard, Nashville, Tennessee, was acquired by the appellant Rachel C. Rome and her husband Rodney E. Snow IV for $925,000. On June the 17th of 2019, Rachel and Rodney Snow were issued an owner-occupied short-term rental permit for 203 Hillwood Boulevard, Nashville, Tennessee, for the main residence. However, based on the Airbnb ad, the carriage house was the rental unit. On June the 17th of 2020, the permit for 203 Hillwood Boulevard expired. June the 28th of 2019, 1508 Cahal Avenue, Nashville, Tennessee, was acquired by the appellant Rachel Rome for $408,800. October the 1st of 2019, Rachel Rome was issued an owner-occupied short-term rental permit for 1509 Cahal Avenue, Nashville, Tennessee. October the 1st of 2020, the permit expired. During the time the permit was active, there were 3 short-term rental hotline complaints and 1 Metro Hub complaint. The previous complaints, the complaints that were submitted during the previous permit are listed. There was 1 hub complaint, and it was on May the 18th of 2020. It was phoned in to the Coast Department, and the comment is, this property is not owner-occupied. The owner lives at another residence. It is the position of the Metro Coast Department that during the time the appellant had the previous owner-occupied short-term rental permit, her primary residence was 203 Hillwood Boulevard, Nashville, Tennessee, and it remained as the primary residence of the appellant and her husband, Rodney Snow, until the property was sold on June the 30th of 2022 for $2,725,000. Subsequently, it is the position of the Codes Department that the appellant and her husband reside at 1920 Championship Boulevard, Franklin, Tennessee. September the 3rd of 2020, 1920 Championship Boulevard, Franklin, Tennessee, was acquired by Prestige Worldwide, LLC for $929,900, which, according to the Tennessee as Secretary of State, Prestige Worldwide LLC's principal office is listed as Rodney E. Snow IV, 1920 Championship Boulevard, Franklin, Tennessee, 37064. The mailing address is listed as Rachel Rome, 1920 Championship Boulevard, Franklin, Tennessee, 37064. The registered agent is listed as Dr. Rodney Snow, 203 Hillwood Boulevard, Nashville, Tennessee. The appellant was previously affiliated with David Price, IMAC Regeneration Center, 1605 Westgate Circle, Brentwood, Tennessee, 37027. The appellant now has a business where she works with her mother, Denise Rome. The name of the business is Mindful Infusions of Tennessee, located at 509 New Highway 96 West, Suite 101, Franklin, Tennessee, 37064. This location is approximately 7 minutes from 1920 Championship Boulevard. Denise Rome, the mother, and Robert Rome live at 1710 Championship Boulevard. According to these ownerships are based upon Williamson County property records, which are included in your packet. The appellant and her husband have at least 3 LLCs. The addresses for the LLCs go back to 203 Hillwood Boulevard, Nashville, Tennessee, or 1920 Championship Boulevard, Franklin, Tennessee. Prestige Worldwide LLC principal office is listed as Rodney E. Snow IV, 1920 Championship Boulevard, Franklin, Tennessee, 37064, and the mailing address is listed as Rachel Rome, 1920 Championship Boulevard, Franklin, Tennessee. The registered agent is listed as Dr. Rodney Snow, 203 Hillwood Boulevard, Nashville, Tennessee. Rome Enterprises LLC, principal office and mailing address is 203 Hillwood Boulevard, Nashville, Tennessee. Agent name, Rachel Rome. Agent address, 203 Hillwood Boulevard, Nashville, Tennessee. Snow Endocrine Consulting LLC, principal office, 1920 Championship Boulevard, Franklin, Tennessee. 825 North 5th Street Boulevard, Nashville, Tennessee. Owner Rodney E. Snow applied for an owner-occupied short-term rental permit, which was denied. 202 Copley Lane, Nashville, Tennessee, was quit claim deeded to Prestige Worldwide LLC from Rodney E. Snow and Rachel C. Rome, husband and wife, according to the deed, the quit claim deed. Rachel Claudette Rome's medical license is Franklin, Tennessee, 37064. Rodney E. Snow's father's obituary of December 29, 2020 reads, Rodney English Snow III, survived by his son and daughter-in-law, Dr. and Mrs. Rodney E. Snow IV of Franklin, Tennessee. And Miss Rome's vehicle is registered at 1920 Championship Boulevard, Franklin, Tennessee, and that does not expire until May the 28th. And I apologize, it looks like we have a typo there, but that's May the 28th of 2023. The supporting documentation for this summary is all in your packet. Is there opposition for this case? There is opposition present, so each side, the appellant and opposition, will have 10 minutes.
Okay. Dr. Rome, if you're available, you can approach the podium. Provide us your name and residential address, and then you may begin your presentation. You'll have 10 minutes.
My name is Rachel Rome. 1509 Cahal Avenue is my residence.
Okay.
I have to say that it's pretty scary, all of the information that was given. I do feel a little violated, honestly, especially prices and things. I don't know if that was fully necessary. Since I only have a short time, I will say, my husband and I, we did own 203 Hillwood Boulevard together. That is correct. We are estranged from each other, which is why I purchased Cahal, and I have remained there as my primary residence this entire time. Now, when COVID hit, I let my short-term rental license expire for a multitude of reasons, not wanting the illness in my home. And honestly didn't think I would ever have a problem getting it back when I was ready. During that process, my parents became ill. As it was stated, they live very close to the Franklin property that was purchased. That was the reason. My father had a stroke and he required round-the-clock care. He didn't want home caregivers in his house. So for the majority of time that I was in Nashville, I stayed at that location. I did return to call on a regular basis, to be honest, for respite from my parents. So I was still returning to that residence. They have thankfully improved some. And at this point, I don't need that location anymore. Living in East Nashville is fine. When I'm here, it's possible to visit, and they don't need me anymore for medical care. So we recently decided to put up the home for rent, which should also be in your records, is a rental agreement we have for 1920. So I'm not sure the documentation that was presented during the time that we had the 1920 Championship Boulevard in Franklin. We did have our LLC's offices out of that location. That's why all of the LLCs are listed there. I don't know if it's been updated yet. The lease only started in May. So when there was also discussion of the fact that my husband also applied for a short-term rental for his new property. We sold 203 Hillwood Boulevard, which you heard. That was where he was residing. And so he bought a new place, but just like me, because of the things that we do, medical consultations, we frequently travel out of town, which allows us to rent the places that we own. Not only do I have a business with my mother in Franklin, if you see, I'm actually the medical director. I'm not currently there all the time. My mother runs the business. I'm also a medical consultant for FDA trials, so I frequently travel out of town. I know that there was, looks like, I guess, several oppositions. I'm aware of one letter that was sent in, and I guess my only rebuttal to that is I know I'm not frequently there, so I could see why someone would think that it's not my primary residence. But from my understanding, there's nothing in the bylaws that state if it's your primary residence within a 30-day period or a year, how much you actually have to be present in your home. I'm typically there anywhere from 3 to 8 days a month, I would say, which again is why I'd like to rent it out. I think that's all I have for now. I guess I'll save my time for rebuttal.
Certainly. The opposition would like to approach the podium. Okay.
Can we review how the timing works when there's multiple opposition present?
There's 10 minutes. They can divide it among themselves as they wish, but nonetheless, there's a total of 10 minutes. And Dr. Rome has 5 minutes and 44 seconds left for rebuttal.
Whoever wants, actually, whenever either one of you speak, if you'll first identify yourselves and your address, please. Thank you.
My name is Julia Trahey. I live at 1927 Riverwood Drive, and I kind of supervise the house next door, which is 1511 Cahal. The owner lives in D.C., so I'm like the handyman / take complaints person. And I don't know, the tenants insist that they've not seen her. I can't speak to that. She's just been really irresponsible about running it, as far as we're concerned. We share a driveway with her. She had parties regularly. Nobody came to clean up the trash. They were using our trash, our recycling. It was attracting rodents. I assume she receives the complaints when they're sent to the city, but nothing changed. The tenants were very uncomfortable. They would have to ask 5 or 6 people to move their cars. I mean, and it happened on a regular basis. So the owner, the tenants, they just would like it, whether or not she meets the residency requirements, she's just not a good STRP manager. That is all I have.
Hi, I'm Robert Davis. I live at 1600 Cahal Avenue. I've not met you before, so hello. I'm in opposition to this, and what I would ask the board to do is to consider the owner-occupied versus non-owner-occupied short-term rental procedures that would be in place and covering Nashville overall. I believe I heard in the opening statements that, she uses the Cahal residence as a respite from Franklin, as well as it seems like there's plenty of items on the record that indicate that there's multiple registrations of things that would generally be used to establish residency that are pointing elsewhere. And so again, my point here would be there seems to be a very clear requirement for establishing and identifying themselves as an owner-occupied location. It seems like there's a way to establish those items in the record to, identify as that owner-occupied, and the bar is set, and the applicant here has not met that bar in terms of what's on the record, would be what my statement would be. So that's everything that I have in regards to what's in front of you guys. So,
thank you so much, Dr. Rome. You have your remaining time for rebuttal.
Okay. I'm sorry to rebut. I'm sorry. What was your name?
Julia.
The complaints that I think you were talking about before, that was, I guess, my previous short-term rental permit. I'm assuming. I'm not sure. It could have been me, so sorry if that was my parties, because I do occasionally have friends over. But with that being said, given the fact that I traveled a lot, I had someone managing those properties. Obviously, that manager was not adequate and was not handling the situations very well. To answer your question, at the time that I had that short-term rental permit, I was not aware of any complaints. So with that being said, if I were granted the possibility of having another short-term rental permit, that I would make sure that the management company that I hire would be set to higher standards. And then to rebut, what was your name? Robert. I would say that the requirements for showing my primary residence as 1509 Cahal, I actually have met. I know there's documentation otherwise, but my point is that that documentation is out of date. And I have proof that that's correct.
Okay. Is there proof that you would like to share with the board that's not contained within the packet?
It should already be in your packet. I sent in the rental agreement. And from my understanding, all the other requirements of the original permit application were met.
Anything more?
No, I don't know if it's going to make a difference, but, it's given the fact that I do travel out of town, it would be nice to be able to rent out my place and it not just sit there. For the management company that I would hire, maybe some of the issues, if your tenants' complaints were recent, it might be because I'm gone so much. That
they're from when you originally had it.
So there shouldn't be any cross conversation between the opposition.
I apologize.
No, that's
I'm sorry.
fine.
I think that's it.
Okay, thank you. Board member questions? Are you looking for it? It was in the front of my materials, probably about 3 or 4 pages in.
If I may ask a question, Dr. Rome, thank you for being here. You mentioned that some of the issues that have been brought up were related to your previous iteration of the short-term rental permit.
The complaints?
I'm sorry?
The complaints were, I believe, the previous short-term rental. Yes, sir.
Was that in your name? Was that permit in your name?
It was in my name. Yes, sir.
Okay.
Because the home's in my name.
Yeah. Okay. And you were living mostly in Franklin at that time?
When I had the short-term rental?
Before, yes.
No, sir. I didn't move to Franklin. Well, I shouldn't say move. I didn't buy the property in Franklin to help my parents out until the short-term rental had already been in place for about a year, and that's when COVID hit, and so I stopped all short-term rentals anyway. And then about 4 or 5 months later, that's when I decided to purchase the Franklin property so that I could be closer to my parents.
Okay, thanks.
Dr. Rome, I'm assuming you possess a valid Tennessee driver's license.
Do.
What address is listed on that driver's license right now?
It's 1509 Cahal.
Okay.
Dr. Rome, what address do you use when you're filing your taxes?
1509 Cahal. Unless it's for an LLC, which previously was at 1920.
Mm-hmm.
But my personal taxes are 1509.
Could you explain to us why the Land Rover vehicle was registered to the Champion Avenue or Championship Boulevard address in Franklin?
Mm-hmm. Because I purchased it through my company, and the LLC is the 1920 Championship address.
Gotcha.
I have a question for Metro.
Okay.
I just want to make sure I have the whole timeline correct because I'm a little confused in the case summary. So we've got Dr. Rome purchasing the Cahal Avenue home in June 2019. In October 2019, she had an owner-occupied permit. That expired in October 2020. But during that 1-year time period, we had these complaints, and then she reapplied on what date? Did she apply on September 1st, 2022? Is that when the application was made? Is that when it was denied? Was it done the same day?
I thought it was in August, but, I'm sorry.
I don't have the date that the permit application was submitted, but they're usually handled in a week or less. So that was the date that the application was reviewed.
And the reason that the zoning administrator denied the permit was because of the complaints?
We had complaints dating back to the previous owner-occupied permit that it was not owner-occupied, and so we looked into it and saw these addresses coming up. We had been aware of the 203 Hillwood Drive address which we had visited and investigating while the permit was in effect. And it's the contention of Metro that that was the residence during the time the owner-occupied permit was active. Therefore, when the application was filed, all of this was on record, and so we had to follow up, do our due diligence in justifying an owner-occupied permit.
Thank you. We just have a lot of information about different properties, and I wanted to make sure I had it all straight in my mind. Dr. Rome, when did you and your husband become estranged?
May, June 2019.
So, despite your estrangement, you and your husband continue to operate a business together via Prestige Worldwide through at least September 3rd of 2020?
Mm-hmm. That is correct.
Okay. And with regard to 1920 Championship Boulevard, is that a residential address or is that a commercial address? Do you know?
It's mixed use.
It's mixed use? Okay. So you didn't have to apply for any variances or anything to operate Prestige out of that location?
No, sir, that's correct.
Any other board member questions? All right, well, if there are none, then we will close the public hearing and begin deliberation.
This is a tough one for me.
Yep, I feel like I have about 12 windows open in my head.
I don't have, I believe this is her primary residence now.
Yeah, I found testimony credible that we've received. I find all the explanations to be reasonable. I don't think Metro's met its burden in terms of proving that this was not her primary residence. And you know, if I'm conflicted and once again could make arguments in either direction, then that's a reason to find that the zoning administrator did here. It needs to be reasonably clear for me to rule otherwise.
Can we open back up? I have a couple of other questions.
Absolutely. We'll reopen the public hearing.
Dr. Rome, in 2019, what address was on your driver's license?
Likely 203 Hillwood Boulevard, because that was my husband and I's mutual living arrangements prior to us living separated.
Okay, when did you change your driver's license from Hillwood Boulevard to Cahal?
Well, if I'm being honest, what actually happened was when I was in Franklin, I got stopped for a ticket. And we had a conversation about what was going on, and the cop told me to actually change my license to the Franklin residence to 1920. So I actually went from 203 Hillwood Boulevard to 1920 Championship. And then when I moved back primarily to 1509 Cahal, and we definitely had it rented, I switched it back to 1509 Cahal.
And refresh my recollection, the timing of that. Like, when were you stopped in Franklin?
Let's see.
This is a two-part question. I'm going to go ahead and give you both parts.
Okay.
When were you stopped in Franklin? And when do you say you moved primarily back in at Cahal?
Oh, okay. I was stopped sometime in 2021. I'm not sure exactly, maybe early 2021. My parents started not requiring as much, I should say my father. My father did not require as much medical supervision as 2021 came to a close. So I actually started spending more time when I was in town at 1509 Cahal. I didn't officially switch my license until we had it rented. And that's just a delay on my part.
I'm going to ask you another two-part question.
Okay.
In 2019, would you say you spent more time in Franklin versus at Cahal versus now in 2022 you spend more time at Cahal versus West Haven?
I would say previously I spent more time in Franklin, and I only went to Cahal just to kind of get away for a little while. Now I spend all of my time at Cahal when I'm in Nashville, other than just visiting my parents in Franklin.
So is it a fair statement to say that beginning in 2022, Cahal was undisputedly your primary residence?
Yes.
Okay.
Yes.
Okay. So if there are no other board questions, we'll again close the public hearing and go back into deliberation.
I will say...
Those are some interesting answers that you just got.
Mr. Vice Chairman?
Yes.
There was one statement made. If you could reopen the public hearing, I could clarify.
Certainly.
The statement for 1920 Championship Boulevard was that it's mixed use. On your screen, you'll see that the general information is 100% residential, or 100 residential. That's the classification. If you'll scroll back up and show that address, please. That's the Williamson County tax record. It is not listed as mixed use.
Dr. Rome?
My only answer to that is that we purchased it for mixed use. That was my understanding. We have run our businesses out of there without any issues prior to it being rented. I guess there was just an error on the purchasing. I mean, I don't know if it was mixed use at one time and then later switched. I don't know.
Thank you. Anything else? We will re-close the public hearing and go back into deliberation. Okay, well, so I was thinking, I was kind of viewing this one way, and now I'm having some thoughts.
I think this is a really challenging one.
It is.
There's kind of an abundance of information that we've been presented as the board here, and then there are plausible explanations for a lot of it. I have a hard time getting past the testimony from neighbors. I mean, it's I live, I know who's on my block, and I know which spots are occupied and which ones are not. It's pretty apparent as a neighbor. So I have a difficult time getting past the fact that folks came out and told us that they don't believe that this person lives at the address that they're seeking an owner-occupied permit for. But there is a lot of information and there's a lot of explanations. So I'm still kind of listening on this one. I'm not sure.
I guess if I'm understanding it correctly, what's I think a bit of a hang up for me is the idea that there was a ticket issued and then advice from a law enforcement officer to change your address to 1920 Championship Boulevard. I'm not sure what would motivate a person to give you such advice other than there being other than that being a residence for you. If it's a place that's just you're there incidentally or it's not your primary residence, I'm not quite understanding where that advice would come from. Maybe I'm misunderstanding something, but it's not quite making sense to me.
I think based on the discussion, particularly in light of the discussion we just had, I don't think it was her primary residence in 2019.
Right.
I think she split her time, but if we're weighing the scales here,
right,
more of that time was in Franklin.
Right.
I don't think it became officially a primary residence until 2022.
And as I understood, there was an admission. There's so much as there was an admission to that extent.
Right. And so for me, looking at it, I do think it would be an owner-occupied permit now.
Yeah.
So then I think the question becomes precisely why did Metro decide to deny the permit?
Mm-hmm.
Because I don't think it was owner-occupied at the time she previously had the owner-occupied permit.
Right.
When the complaints were filed.
Right.
And I don't want to speak for Metro, but there is email correspondence in our packet between the appellant and someone at Codes that says, we're unable to issue your permit because you reside at 1920 Championship. I believe that's the right address. There were several.
Yep.
So that was the reason the permit was not issued.
Right, because I don't think...
I believe September 1st of this year. I thought I wrote it down, but...
Because if that's the stated reason why it's denied, that if the stated reason for Metro is we're not issuing it because your primary residence is Franklin right now, then that's different than we're not issuing it because you operated in the past under an owner-occupied permit. It was not owner-occupied and you had complaints from your neighbors.
Right.
You may want to get clarification from staff then.
Well, but can you tell me where that email is that you would?
I have shuffled my papers around. It was near the back. It was near the back.
Okay.
I'm looking.
All right.
I'm looking. Okay, yeah, it is literally the last several pages of the packet.
Okay. It was my very last page. I haven't moved those around. And apologies, this is a very document-intensive one, so
This is a dense
we
file.
want to make sure we get it all right.
And the date is on the previous page.
Right, so to me, I'm looking at, September 1, 2022, 10:28 a.m., seeing that you primarily reside at 1920 Championship Boulevard, Franklin, Tennessee, we will be unable to approve your short-term rental application at this time. And if that's the stated reason, and we've heard testimony that this is now her primary residence starting in 2022, I'm inclined to say there was an error.
Okay. So, and you're saying are you considering it the date by which, or the approximated date, the April 2022 when the lease became effective for Championship Boulevard?
So the lease, I thought the lease became effective on May 1, 2022.
Right.
She applied for this permit in August or September 2022.
Right. And that, okay.
And if she's putting personal taxes address at Cahal, her license says Cahal, I will say I am discouraged by past behavior when there was a permit, and I do not like seeing the complaints, and I'm empathetic to the neighbors. because that's not how it should be operated. And I think if those complaints continue, when it comes time for renewal, there will be an issue.
Yeah.
I'm trying to separate
Sure.
the two issues.
Yeah, unfortunately, I don't think the complaints are pertinent to the question that we have to answer
Correct.
in this case.
I think the stated reason from Metro is you reside in Franklin, that's why we're denying
Right.
it. And so because we are governed by
Right.
where we have to determine whether it was an error, I think the error has to focus on why it was denied.
Agreed.
I will say that we have testimony counter to the claim of owner occupancy from neighbors.
Can we open it back up and ask her to show us her driver's license?
Sure.
I mean, that's you can change that at the kiosk in the other room.
I think we are entitled to interpret it different ways. I think that if she is traveling, she has family here, she's estranged from her husband. I think the situation has probably evolved since
Right.
2019, 2020.
And it's a brave choice to choose to lie to the government about where your primary residence is when you're getting ready to file taxes. Or it certainly would be. If you'd like to view the license, I'm happy to open back up public hearing to do that.
I don't want to monopolize this conversation.
You're doing well.
Sure. Let's go ahead and reopen in the interest of making as good a decision as possible. And this is a rather convoluted set of facts. Thank you. Let's see here. Where is the issue date? Yeah, that's what I was looking for.
What does it say about the expiration date?
The expiration date is 5/6 of 2027. The issue date is 5/4 of 2022. So that tracks with what we were told as far as the primary residence converting to Cahal whenever the lease became effective. I mean, certainly. Yes, we will close for the last time, I believe, the proof and go back into deliberation. Certainly it's not a case of perfect proof on either side, but I think that the weight of the evidence militates in favor of Dr. Rome's story for me, or her recitation of the facts for me. I just don't know that I could comfortably determine that the administrator did not err here.
I think the point that you made earlier, Vice Chair, that if there is, and we've seen it previously today too, if there's ambiguity, we have to consider that as well. And I would tend to agree with you.
Okay, well, anyone else have any further commentary before we open the floor for a motion? In that, given that, I will move that we find that the administrator did err, and that the appellant is entitled to apply for a new short-term rental permit at her leisure.
Second.
All in favor? Aye. All opposed? All right. Dr. Rome, your request for relief is granted. You may apply for a new application for an STRP at your leisure.
So I have to apply for another one? Or does my original application stand?
That's what I was about to say. Yeah,
Okay.
that'll be a question for staff to answer. Thank you. And thank you, folks appearing in opposition, for your time. Oh, my God. Ed?
Last case before the board is 2022-45, 1021 10th Avenue North. This is for operating with an expired permit. It's governed by 2017-608, the effective date of which is 2/2/18. 1 year wait for advertising and operating with an expired permit, and the board has discretion to lessen that period of time. April 17th of 2019, VRBO website advertisement was posted. May 14th of 2019, the owner-occupied permit application was initiated. May 19th, May of 2019, host compliance has 2 document stays, cached VRBO ad printed and has 2 reviews. That's included in your packet. June the 7th of 2019, the permit was issued. March 18 of 2020, the program manager, Robert Osborne, found a website advertisement advertising excess occupancy, excess bedrooms, and the permit number not displayed. The ad was corrected within the remedial time period, and the case was closed. On June the 8th of 2021, the permit was renewed. January 25th of 2022, the Airbnb website advertisement was posted. June the 8th of 2022, the permit expired. June of 2022, there were 3 documented stays. In July of 2022, there was 1 documented stay. August the 3rd, 2022, the address was on a monthly list of properties advertising and operating without a permit or with an expired permit provided by Metro's compliance contractor, Granicus Host Compliance, for follow-up investigation. A notice of violation was sent by Inspector John Feltz for advertising operating with an expired permit. On August the 7th of 2022, the appellant emailed Program Manager Robert Osborne about permit renewal throughout August, the gist of which is the appellant, Mr. Thompson, was under the impression that he had sent the renewal documentation and payment earlier. The Codes Department had no record of that. It was now well past the 30-day renewal grace period, and Mr. Osborne asked if the appellant could provide any documentation for what he had sent. The appellant was not able to provide the requested documentation. Mr. Osborne informed the appellant that he would have to apply for a new permit. On September the 1st of 2022, the permit application was submitted. On September the 7th of 2022, Administrative Officer Madison Neal processed the application, and as a matter of course, Officer Neal found that the short-term rental property had continued to advertise and operate after the permit had expired. Officer Neal informed the appellant that he would have to wait a year to reapply or appeal to the short-term rental board in accordance with the Metro short-term rental property ordinance. August of 2022, there were 3 documented stays. September of 2022, there was 1 documented stay, and the short-term rental appeal application was submitted just after September 14th filing date for the October short-term rental meeting cutoff. The October 2022, where there was 1 documented stay, and October 17th, 2022, the STRP appeal was filed for the November 30th, 2022 short-term rental board meeting. There was 1 complaint on the property for advertising excess occupancy and excess bedrooms. July the 14th of 2020, Campbell Paget, notice of violation on an email complaint.
That concludes the city's presentation. Mr. Thompson, we'll hear from you. Is there any opposition?
Yes, sir. Quick procedure. Is there any additional documentation here that I don't have a copy to, or is this? I know that I've noticed in the prior proceedings that I would scroll through and I'd see information on the screen, so I don't know if there's additional stuff here that maybe they don't have. So I'm trying to have a copy of everything.
You should have received a copy of the entire case.
All right. Mr. Thompson, if you will give us your name and your residential address, and then you may begin. You'll have 5 minutes.
Thank you. My name is Dallas Thompson. I reside, I think, on Marriott. It's when that's not the case, I'm at the 19th Prairie Commerce District, and I'm at 1021 North. First off, I would just claim personal accountability and responsibility for the fact that it was my responsibility. The city of Nashville did send out a notification, I think in January, stating that they were going to change the process. I actually posted that notification on my fridge, was extremely confident that like I had actually got the affidavit signed and notarized to return back along with the payment for the renewal. So I am guilty of operating my property as a short-term rental without the required permit. My intent was not there. I was doing it unknowingly because I was under the complete understanding that I had renewed the permit and that my permit was in good standing. I have learned through the process. I've made mistakes along the way. So, for example, I, made the error of having the wrong guest counts or having the inaccuracy of the bedrooms there at the house. And so I take...
Mr. Thompson, your microphone is not on.
Right. You guys not hear me?
I hadn't even noticed. I could hear you. But go ahead.
And so when notified of those things, I made the adjustments immediately because I understand the complexity and I understand that, like, it's a very delicate matter that you guys deal with. And so, can I pay my bills without this? Yes. But does the money make a difference? Absolutely. So I'm not going to claim that, like, this... without this, I can't pay my mortgage. I did, after the notification, contacted Airbnb and VRBO, and was my time already up? Stated I've got to work through the fact that my permit's expired. I need to move these bookings. They helped me move several bookings. I called guests trying to move some of the bookings. It was very telling. I actually had one guest tell me that, like, they'd been to 3 or 4 events in Nashville. 2 or 3 of the houses they showed up to weren't even the houses, like, on the things, and then, like, they were, like, in different parts of the city, and they really didn't want to move because they had, like, grandma's birthday party, and she, like, lived around the street corner. So we were able to move a good portion of everything. If I were to cancel, it's kind of like a death situation, because if I were to actually cancel everything of my own accord, then the Airbnb would then no longer do business with me ever again because of a cancellation policy they have where if you cancel too much as a host, that they completely cut you out. So I try to do the right thing. I don't know if I was successful in that. And try to move every guest out and cancel, like, the existing bookings. Several were postponed and canceled. I can show you my calendar now, and you'll see that there are no bookings like in December, January, February, March, April. And typically, like, those are already booked out because people start booking those. So I can show you that, like, there has been that impact. So I'm just trying to do the best job I can, and I realize that, like, there's intent, and I'm guilty of absolutely failing to renew that, and I thought I had. And my intent was not malicious. I pay my taxes. But I know you guys are in a tough situation with these things, so hopefully intent is important in the letter of the law, and we can get this permit in good standing. I'm happy to pay whatever associated fees would be required of that, and then everybody can move forward. So I've got my driver's license. Everybody keeps asking about addresses. I took my insurance copy. It's got my address on there as well. You can look. I don't have, like, another utility bill like at a different house.
But happy to answer any questions. And I know that this isn't easy for you guys at all. And hopefully we can find a way to work through a solution that other than waiting, a year to be able to STR the house again.
So I have a question, Mr. Thompson. On what date did you notice that the payment that would have gone with the renewal you thought you sent had not left your bank account? Well, first, actually, I'm sorry. This is a two-part question.
That's a very.
When did you think you sent it, and then when did you notice that the payment that would have gone with it did not leave your bank account?
Yes, sir. I work for a very unique company, and I run all my corporate expenses through there. So if there's $20,000, $30,000, $40,000 on a credit card, I won't notice it. A lot of it gets expensed through the corporation. So the $300 or $500 payment is something I would never, sadly, in a million years notice.
Okay. When do you think that you actually sent the application in?
April, May time frame.
April, May of 2022?
Yes, sir.
2022?
Yes, sir.
Okay.
And I always try to, the thought is if you can send it in a couple months early. And I even looked because I thought I actually had a notarized copy of when I actually got that document signed with the date, because I was like, that'll be what I need to find to be able to show that that got sent in. And I had trouble finding that.
So once you'd emailed Mr. Osborne in August, it didn't occur to you to go back to your ledger for your credit card statement for that month and look and see whether the payment had processed?
No, I did, but I realized I think the failure was that I put everything together and it just never got sent in.
Gotcha.
Yeah.
Gotcha.
Yeah.
Okay, I'm sorry. I apologize.
No, but that's the best thing would have been hey, had the payment been made? That's probably I never, to answer your question. No, I never did go look. Okay. It didn't occur to me to look for that. The people that run this business, you guys are very competent. You know what you're doing. I trust that everybody does and tries to do the right thing. So I believe them. If they don't see it, then they don't see it. And I have to take accountability and responsibility. Right. Is there a chance I sent it and it got lost in the mail? Sure. Probably unlikely. I mean, the likelihood is it never made the mailbox, and for whatever reason I failed.
And I'm sure that even you would acknowledge that even if you had sent it in without the payment, it's incomplete.
No, I would. The payment absolutely would have been attached. Even in my, I got a check here. I've got a copy of the package. So I absolutely would have included a payment.
No, that's not what I'm saying. What I'm saying is, since you know now that no payment process that you've made from the credit card that you said you used for your business expenses, you can acknowledge that even if you had sent those things, your application would have been incomplete because the payment would have been missing.
My payment would have been with it. So my payment would have been included with the application, so it would have been completed.
Okay, then I'm confused.
But no, I think you're right. Had an application without a payment is incomplete.
Right.
I agree with that.
You made a reference earlier to a credit card that you used for your business expenses, so that led me to believe that a credit card would have been a credit card ledger would have been the documentation you were using to support the fact that you did make a timely application.
Yeah, I believe the question was why didn't I see why didn't I personally, when I looked at my May or June bank statement, not recognize that there wasn't a deduction for, $350? And my response to that was, in the line of work that I have, and what we do, which is very, very unique, where we'll go, I can't speak actually under NDA and what we do, but if there is a charge of $3,000 or $7,000 or $2,000 that the company pays for, right? But I put it on the credit card, that'll get reimbursed. So that whether it's that or going through the details of my checking account, it's not something that I do on a daily basis. It's just not a routine I have.
Gotcha.
which is why, like, if there's $500, like, in missing, I was an orphan. I grew up with nothing. I went to the Air Force Academy, graduated in 2001. I've been extremely blessed. Like, I'm very lucky to have a house that's worth $1 million. I know that, like, a lot of people can't afford that. Like, I'm very, very lucky. And looking at my checking account, like, if it had a variance of like $300 or $1,000, I wouldn't notice. If it had a variance of $10,000, like, I would absolutely notice, but I kind of keep a running tally of what's in my mind, what's in the account, and then like a $300 payment's not something that would, you know, I've just been very blessed. I wouldn't notice the difference between a balance of $7,500 or $7,800 on my bank account.
Got it. Board members?
Have I just missed it? Do we have a copy of the notice of violation?
I didn't see it. I have the press.
I may have a copy of that, actually. It's right here, I think.
Let's see.
Yeah, I have a copy of the notice of violation if you'd like a copy of it.
Oh.
It's dated in August, and I think I immediately emailed Nashville saying I thought I actually had a good permit.
All right. Oh, gosh, try it again. Try to turn it off. And everyone turn yours off? You're good. That's weird. That's not my house. But that last picture was of my house.
Okay, so you were aware that, Mr. Thompson, that the notice of violation says no person or entity shall operate a short-term rental or advertise without a permit, correct?
Yes, ma'am, that's correct. When I got the violation notice in August, I was aware of that, and that's when I contacted Airbnb and started working to cancel bookings. Did I go out and cancel 100% of everything? No, because then the Airbnb never works with you, but we move people, they move to different houses. Some people refuse to cancel. They're like, we booked your house, we have to stay there. And it's like, what do? You leave somebody out on the street and then you're in violation with the city, or do you not do that and then Airbnb will never let you work with them again, right? So it kind of puts you in this very awkward situation. So I tried to make the best judgment where I could, and I don't know that I made the right judgments. I may have made errors in that process.
A question for Metro. At the very end of the case summary, it says there was one complaint on the property for advertising excess occupancy and excess bedrooms. Are those what were discussed earlier, where the notice of violation was sent and it was remedied, or is there a different complaint that I don't see that we have a copy of? I just want clarity on whether or not there's actually a complaint about from like a neighbor or anything.
Yes, there was a complaint about the excess occupancy and excess bedrooms.
From a neighbor, or?
It was on the short-term rental hotline.
Okay. And so since that was on the phone on the hotline, we don't have any record of it.
Well, since the case was resolved, we didn't include that.
Okay, so that's what I was getting at. So when, that was in 2020, correct? And then it was remedied?
Yes.
Okay.
So if it was remedied, then the number of guests would be correct in our printout, because I'm seeing 25 on one and 16 on another. So I guess what I'm asking is this, like the HomeAway sheet, is this current, or is this from 2 years ago as well?
I could probably clarify on some of that. It's helpful. So
I'd like to ask Mr. Phelps first, just as to when this was pulled. This shows 25. This is HomeAway, And then there's another one that shows 16 as the total guests and different room counts and the air cover, I think. I don't know what I'm not familiar with air cover personally.
Can you give me the date of the advertisement you're looking at?
Yeah, I don't know if this has I don't know what the date is on this like this one here from HomeAway. There is a date on it, but I don't know what that date is. It says 2019. But then the screenshots.
Does it say at the top
2022.
June 5th, 2019?
Yeah. I'm sorry, could you repeat that?
Does it say at the top left June 5th of 2019?
Yes.
Okay, then we're looking at the same ad. What was the question?
So if this, so the June 5th, 2019, what is that when this was created and then it was printed on November 10th, 2022?
This is a cash aid ad. Veronica's Host Compliance scans ads approximately every 3 days. Mm-hmm. Approximately every 2 weeks, they will cachet a copy of the advertisement. This is the earliest cachet advertisement.
Okay.
On Host Compliance.
So it may be different if it was changed.
And Mr. Loico, I can. Mm-hmm. So when I got the notification in 2020 that I was inappropriately advertising the property, I actually got on with the STR team here in Nashville and spoke to them and reviewed the ad in detail. And one of the things that my thing will host is like a boys club dinner or like a Boy Scout jamboree or a girls club, whatever. And in those events, they'll have like a dinner that'll have more than 16, 20 people that will be at the residence. And so we looked at the fire code, which will allow up to 25 people, but they're not allowed to stay the night there. They would come in and they would have a dinner. And so I actually worked with the STR group here in Nashville, the Codes Committee, and they verified what language would have to be accurate so that those groups could still do those events and I could advertise it appropriately. So if there's anything that's inaccurate or needs to be changed, like I will absolutely make the change, but I made that based upon their governance. And I think if there was a way to like go into if I were to reactivate the listing and go in, you would see language that would explain that, like, you can only have X amount of people stay during the night, but if it's more than 30 days, you can do this. But if it's like an event, like a dinner for a boys club or Girl Scouts or whatever, then you could have additional people there, but they can't stay the night.
I guess what I'm having trouble with what you just said is that it says sleeps 25. Like that's the exact wording on the...
Yeah, I think in the 2019, 2020, I believe that's why they actually reached out for the violation because of that language. Mm-hmm. And then the changes that we worked through, that was one of the things that was corrected.
Okay.
Let me ask this point of clarification. Do you still advertise on HomeAway?
I've had about 10 to 20 advertising sources. Okay. And the biggest challenge that you have is some of them actually will create separate ads. So like HomeAway, for example, is owned by Expedia. And so you have to shut like everything down. And even in that process, if you forget to shut something down, it won't. But the answer to your question is no, I do not advertise on HomeAway, and I can pull up like the applications right now and show you that I have the listings ceased there.
So if we were to pull up your listing on HomeAway today, there would not be a listing for your property?
Yeah, I can. Do you want me to show that right now?
Is there a listing on HomeAway for your property right now?
No, there's not, but okay. I can show that if you'd like to. I can pull it up right here.
No, so I think I understand what you're saying about the confusion, and I'm not 100% sure. I think this is from 2019.
I tend to believe the same. Yeah, I think anything relating to number of bedrooms available and the number that it sleeps is related to the 2 notices of violation that were resolved, that were closed for compliance.
And you try to do the right thing. So the other thing that'll happen is there'll be like a staff change or a policy change, and then like you get notified and you make that change immediately. And so in my line of work, I get like the complexity of the policy and everything that everybody works through, and it's not a simple issue. So it may very well be that hundreds of properties right now are out of policy unknowingly, but that's why I specifically got the approval from the STR group on the wording. And I will absolutely, if it's the best thing to do, we can make, the permit contingent upon complete approval by them as well on the marketing setup of the property as well. And I don't use third-party groups. I don't need to. I'm here. I do have maids when I'm traveling that become contacts, but that helps me control somewhat of the fact that like so many of these websites will like interchange, and they have software programs that you buy that like help you maximize the price. So like you'll buy a software platform and it lets you build the listing once on Airbnb, and then it grabs that listing and it puts it on VRBO and puts it on Expedia and puts it on Google has a platform. Right? Marriott Vacations has a platform, and it puts it on all those elements. And so I think the biggest challenge in shutting things down was going back in through that software and making sure that they actually shut off, like, because my house will show up on Marriott Vacations as a Marriott, whatever, is making sure that all those elements get shut down.
If you pull up your Airbnb profile right now, what does it say under the About section?
Let me see. Let me pull it up right now. Airbnb on the About section.
It says you, not your listing.
I have an error pulling it up. I'm getting 3 lines. What do you see?
Does that mean the website's thinking, or does that mean there's nothing?
I just know if I'm getting reception.
Okay, gotcha.
Yeah, it's not listed. It's deactivated on Airbnb. I do have like a couple other properties that I manage, but yeah.
So you're not on Airbnb right now?
This specific property is not on Airbnb.
Okay.
It's not listed on Airbnb, and it has no future bookings. So I actually took screenshots as well of both Airbnb and VRBO, and I can show you guys that like if you look at the calendar, there's no bookings on those platforms.
I'm just curious what your profile says, though, under the About. If you've got other properties that you're saying you manage?
I haven't touched that profile for probably 6 or 7 years, so I don't know.
Okay. The printout that we have says lives in Austin, Texas. Can you give us insight on that?
Yeah, when I set up my Airbnb profile, that's where I live, and I haven't touched it for 6 and 7 years. I do travel extensively. I have a second home in Austin, Texas. I was born and raised in Texas, and so I have a second home, a lake home in Texas. But I can give you my driver's license. I can give you, this came in the mail, and I thought it was very interesting. It's my employment, my healthcare insurance, which is probably like, I don't know how more real you can get than that. You can see like on here, if you want to see, I've got my, address, employee ID.
I don't know that occupancy was part of this case.
It's a fair question.
This is a discretion case, so I'm just looking and asking the question.
Thank you.
Right.
Okay.
Yeah, I think it's a very fair question, but I've got like my employee benefits here. And I think you make, Ms. Kimberly, I think it's a really good point. I probably need to go back into my profiles and make sure that I update that information because it's been 5 or 6 years.
Mr. Thompson, I just took the URL at the bottom of the ad that we have a picture of, and I clicked on the link. It's valid, and I went to the calendar. And I'm looking now at a December 5th through 7th prospective reservation at $325 a night. And the link that says reserved is illuminated, so it's active.
No, it's not active. It should not be. It's right here.
It's giving me a price before taxes.
If you have a URL, that may be different because you're going to a specific URL and they may not have it cut off, but I can show you right now that it's unlisted on an application. I think any URL, just from a technical perspective, if you have a specific URL?
I have the URL that says www.airbnb.com, users show 128-64396.
Do you want to try to book it and see what happens?
Yep.
But I can show you right here on my application, it's unlisted.
It says request to book. It's got my 615-946-2677. Continue. I know, right?
And I don't know if that's a different engine, but I can, on my Airbnb app, it is unlisted.
My number, hold on, they're sending me an SMS code. Join cancellation is non-refundable. Okay. All it's asking me to do is to update my card. It's giving me an option for travel insurance.
Let me ask you this, if you do a search, if you go in through, this may be the better way instead of the URL because it'll be accurate, if you actually go onto Airbnb's website, and then
I don't think this is an archived listing.
No, I bet if you go into Airbnb's website just go into the standard website, do a search, and you could probably go in on the map and zone in specifically and on my street and look at the house, see if it pops up.
Okay.
Because it is, if you want to look, it's here, it is unlisted.
Okay.
And I will bring you.
Let me ask you this question. Do you have a booking for December? Booking for December?
I do not believe so. No, I'm almost confident there's not. I took pictures of the calendar, and I'd love to be able to show this to you. So I can go into the property. Here's the the property here. It's unlisted, right? And if I go in and I go to calendar,
God, this needs somebody else that's a little more savvy than me.
Yeah, I think when you copy the URL, it actually...
a lot of websites, when something like that happens, like a URL, they'll, if you want to...
I can't even load the calendar data right now is what it's showing me.
So you mean they'll keep a cache copy?
They'll keep the URL because if you're going to renew it, they don't want to redo the whole thing again.
Right. I would think they would give me an error message, though, way before I get to the point where I'm ready to input my credit card information.
Well, yes and no. It just depends on how lazy they are.
Yeah.
But if you do a search, it wouldn't show up because it's not active.
Right.
Yeah, it's caching that URL.
Okay, hold on just a second.
Is what it's doing.
Okay, I see a 1020. That's Platform Way North.
So here's my calendar in Airbnb. in December, and there are no bookings.
Okay. And your property's before Charlotte Avenue, correct? South of Charlotte Avenue?
Yeah, I'm 1021 South, so I'm just off Jefferson.
Okay. Okay.
Yeah, so there were like Rosa Parks in Jefferson, and they just tore down like the churches right there. Mm-hmm. To near Germantown.
I'm familiar. Okay.
A lot of crazy construction going on.
Oh yeah, not far from where I live. Okay. I think I've crawled down that rabbit hole far enough.
And then here's the insurance, if you need to see that too, or anything else that you guys need.
I don't think germane to this particular question. Any other board member questions? Okay, well then, if there are none, we will close the public hearing and move into deliberations.
Just on the instant issue that we were just discussing as to whether or not it's active on Airbnb, I'm inclined to, if it's not showing up for him, I think it's a weird glitch of some sort.
Very weird.
But if it's not showing up for him,
yeah,
I'm going that direction, that it's not active.
Okay.
I think that, we don't really have, the complaint that we had was, I'm satisfied with the response about the complaint that we had about excess occupancy, and that's been resolved. So in my mind, that's not weighing for me. I appreciate the letter in support from his neighbor. I think that is a nice thing to add in his favor. I do not like that the stays occurred after the notice of violation was sent. I don't think that is something that we can just turn a blind eye to.
Right.
I would be inclined to reduce the waiting period. I'm not entirely sure what, but I would be inclined to grant some relief.
Okay.
Because I think he is a responsible operator.
I thought I saw my papers are all shuffled up and I can't find the cover page, but I don't know that this is one of the cases where we do have the discretion to reduce it without determining that the zoning administrator erred.
We do have discretion.
This is discretion. Okay.
1 year wait.
Which is why I was asking some of those other questions.
I'm in agreement, in that I'm willing to go for some reduction, although I'm not, it is hard seeing documented stays in October, documents stay in October. That's our wrestling as to where to start the date.
So, yeah. Okay. 1, 2, 3, 4, 5. Okay. 9 documented stays, yeah. It is a lot.
Yeah, we had about probably 20 and got the majority moved. And one in October was interesting. Was
Right.
People were all ladies and had family in the area and they just refused.
So the public hearing's actually closed. We're not allowed to address the board any further. This is just us talking amongst ourselves. That's okay. Okay, so if we take into account 9 stays, let's see here. That puts us into.
Not inclined to grant relief.
No, I'm inclined to grant some relief.
Excuse me, yes, I'm inclined to grant time. But I think the one thing, the documented stay in October was kind of a killer. Otherwise, I would have said, reduce it, basically to now. I think he's shown very good response, very good management in doing this, and his comments and directing comments to the board, the board. I think we're good. I would say reduce it to 4 months.
So here's where I come down on it. I wasn't even going to look at all of these days that occurred after the expiration, because I think that I certainly think that you could have handled it more responsibly in terms of tracking down the application and the payment. But I was going to look at it from August 7th when the first question arose as to whether or not the expiration was valid, and then look at the stays after that and sort of assess the number of months based on the number of documented stays we have. So that would put us from October, it would put us there are 5 documented stays, 5 months. A 5-month waiting period. So a 7-month reduction.
I'm going to have a hard time because of the documented stays after the expiration, and the issue was brought up again on the 7th. I have a hard time getting under the 6-month point in cases where we had stays after staff has. Metro staff has utilized Metro resources to go and contact someone about it. I have a hard time going below 6 on that.
6 months I find 6 months to be acceptable.
I agree, and I hesitate to start with the precedent of a month per stay. I understand, because that thought went through my mind, and I almost said the same, but I'm hesitant for us to put that precedent out there.
Sure.
And go ahead. I don't mean to interrupt you. I mean, I agree with that. The things that I look for are, actions to correct, and especially after being contacted by staff. And it appears that we had some here. But, we have people that come in here and have just nuked all their bookings and just said, I'm sorry, platform. I'm sorry, guests.
Right.
It's not happening.
Right.
And, I understand that different people have different circumstances, but that is what some people do when they come in front of us and they've lapsed their permit and they've are seeking relief. So I think that we have to, for me, that's one of the big things that I look for. And so I think 6 is the most relief that I would be comfortable with personally.
Okay.
Does anybody recall when the ads came down?
Oh, let's see.
The advertisements?
What do we have in the...
I don't know that we have.
I don't think that's in there.
When they came down.
Yeah, I don't think that's in there. If it's
So, well, on the front part of the packet on September 7th, it says that that they continue to advertise after it expired. Well, it doesn't have a date as to. Yeah, I don't know.
The factual summary is silent, but we can certainly open back up the public hearing and ask that question if we need to.
What date are we thinking we're going off of? The date of the last violation? Isn't that what we do?
Yes,
So
and I was going to
and then
October.
it's from then.
Mm-hmm. So are we thinking? So the last suggestion that I heard was 6 months.
I think it's 6 months at a minimum.
Mm-hmm. Okay.
6 months of reduction. 6 months of reduction or 6 month
waiting
minimum.
period.
Yeah, that's kind of
A minimum of a 6 month waiting period.
that's my position as well.
Okay.
Well, I don't.
There's no motion yet.
I'm open to suggestions but I think I'm going to be comfortable with whatever the body decides.
What seems like a reasonable time period for you guys?
Are we talking 6 months from October? Okay.
And I think, again, we don't have when the stay was in October, so I think we just have to set a date in October. I think October 1 is fair.
That was my thought.
On September 7th, it says officers will inform the appellant that they have to wait a year to reply. I would assume that September 7th was the year.
But I think that's because there was an application pending. I think now that once we had the stay after that fact, I think that changes the calculus a little bit. See, I think October's definitely the starting point, but
we say the six-month reduction according to the date set by zoning board?
We could pick the date.
Let them.
Yep.
I think we have in the past, and I think we can with the discretion cases, pick the date. We'd go with the last violation.
Last violation is, that's been pretty consistent.
What I'm saying is, in my mind, it's somewhere between a 6 and a 9 month waiting period. So a 3 to a 6 month reduction. And I'm polling the audience here as to what you all, where you come down in that range.
8 was kind of the number that after we said at least 6, I think 8 was the number that popped into my head.
I think that the weight should be more than 6 because 6 is what this body has granted people who have gone a little bit more above and beyond to correct the violations. And I'd like to be somewhat consistent as a body. So 7, 8, I think 7, 8 is fine with me.
I'm good with 8.
Okay.
Sure. I make a motion that we reduce the year by 4 months, starting, which would start from October 1st, 2022.
That's a good motion. Second. All in favor? Aye. Any opposed? All right. Mr. Thompson, the decision of the board is that you will be required to wait 8 months from October 1st before making new application for an STRP permit. An STRP.
It's like ATM machine.
Yeah.
Just one thing to share. Thanks, guys. I appreciate everything you kind of started. The last 45 days, Airbnb changed the policy.
Well, so there's not going to be any other opportunity to address the board. I'm afraid that the matter has now been determined.
I just wanted to share this for your own awareness.
I don't think that opportunity is available, and it's been.
Our emails are listed on the Metro. Just for your own knowledge and your own awareness, in the last 45 days, Airbnb's changed their policy where if you cancel 3 bookings, they will cancel you as opposed to not.
I get it, but that is in reference to what we were just discussing. So again,
I was just sharing that so you know. And I
understood. Thank you.
I appreciate your time.
Yep. Yeah. Thank you.
Would you like to adjourn the meeting?
I'm sorry?
Would you like to adjourn the meeting?
I'm about to do that. Yes, I'll entertain a motion to adjourn.
So moved.
All right. All in favor?
Aye.
Great.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.